All rise.
Hearing the appeal, Office of Communications, UKSC Information Officer.
My Lords, I appear together with Mr Chowdhury for the Appellant, the Information Commissioner, and Miss Rose together with Miss Collier and Mr Potter appear for the Respondent, Ofcom. And my Lords will know that this case raises a short but important point concerning the proper interpretation of Regulation 12.1 of the Environmental Information Regulation.
Is this a case for a reference?
It may ultimately be a case for reference if the following two hurdles are not crossed. If your Lordships are content that our construction of the domestic regulations is correct as a matter of domestic law, then no reference need arise because Recital 20 of the Directive and General Principles of Community Law would allow us to go, if you like, further than the Directive. Were your Lordships to be against us on the question of the construction of the domestic regulations as a matter purely of domestic law, then your Lordships would have to look at the Directive, because we say the Directive not only permits, but requires the interpretation that we adopt. And in that situation, if your Lordships and your Ladyship were satisfied that it was act clear that the Directive means what we say it means, then again, there would be no requirement for a reference. But if your Lordships were against us on domestic law, and were not satisfied that the Directive was act clear in the way that we would say it is act clear, then your Lordships would be under duty under Section 234 or Article 234, sub-Article 3 of the Treaty of Rome to make a reference.
Is there not a middle position where we would find it quite difficult to decide which side is right? I mean, that's a situation where it's really not act clear. We can't be absolutely certain one way or another.
If your Lordship reaches the view that the case turns on the interpretation of the Directive, and if your Lordship reaches the view that it is not act clear in either direction, then your Lordships would have to refer. If, however, you are satisfied that as a matter of purely domestic construction, the regulations mean what we say they mean, then your Lordships need not make a reference, because the Directive contemplates that we could, if we wish, to go further as a matter of domestic law, and that's set out in Recital 20, which is in tab 5. I don't know if your Lordships have looked at the Directive before.
This is in Bundle 1. Yeah.
Because on this analysis, on this hypothesis, we would be making it, if you like, easier for the individual to get access or more difficult for the public body to refuse access. And if your Lordships go to, I beg your pardon, it's Recital 24.
Yes, 20 doesn't seem to be on the point at all.
Beg your pardon? No, it's 24, my Lord, it's my mistake. The provisions of this directive shall not affect the right of the Member State to maintain or introduce measures providing for broader access.
Well, that's consistent with the word may in Article 4, isn't it? Member States may provide, means they...
Exactly, they don't have to.
Yeah.
The recital sets out the policy, and then that's followed through, as my Lord Mance correctly observes, with respect, that it's a permissive thing. So we could, in fact, do what is permitted by Article 4, and also we could have even more limited restrictions, if we wished. So, as a matter of, your Lordships do need to decide this as a matter of domestic law first, and if we are right on domestic law, then that is the end of the matter. If, however, your Lordships are concerned that we are wrong as a matter of domestic law, then your Lordships do need to consider, is the Directive Act clear in the way that we say it is?
Yeah. Could the Court of Appeal have referred?
They had a discretion under Article 34.2. They had a discretion, your Lordships have a duty.
They don't seem to consider it.
They did consider a number of things, including Regulation 12.4, but I'm not criticising the Court of Appeal. It's a very busy court and has a lot of things to do. But they didn't consider a reference, and they didn't, or they don't certainly record in the judgment. I wasn't obviously present in the Court of Appeal, and they don't seem to look at the relationship between Regulation 12.4 and Regulation 12.5. But they have a discretion, your Lordships have a duty, as you will be well aware. Subject to any further questions about the reference, I shall summarise the appellant's submissions on the question of construction and then turn in more detail to the regulations and to the directive. In brief, as your Lordship and your Ladyship know, the regulations oblige public authorities to make environmental information available on request. Regulation 12 provides for a limited exception to that duty. Namely, a public authority may refuse to disclose environmental information if an exception in Regulation 12.4 or 5 applies, and if the public interest in maintaining the exception outweighs the public interest in disclosure. In the submission of the appellant, if an exception is relied upon as justifying non-disclosure, the proper approach is to consider first, is that exception applicable? And second, if so, does the public interest in maintaining the exception outweigh the public interest in disclosure?
I'm sorry to interrupt. I mean, can I just go back to your starting point? You're asking us to construe the English regulations in the abstract, are you, without any European background? I question that. Surely, in order to, I mean, the likelihood is that the Parliament didn't intend to draw the fine distinction, or any fine distinction, between the way it implemented the directive and the directive. In other words, the likelihood is that it didn't actually intend to restrict, to exercise the freedom under recital 24, or it would have made it a lot clearer, one suspects. I mean, the likelihood is they just transposed it into what appeared to be the appropriate domestic language. And therefore, actually, don't we have to form a view as to the meaning of the directive in order to work out what the regulations mean? And your rather subtle point that we can consider the regulations and forget about the European position fades away.
No, my Lord, for this reason. If, to take my Lord Hope's analysis, and it is unclear what the directives meant on this particular issue, and if it was not that clear, then the interpretation that the draftsman, the English or British or Welsh or Northern Irish draftsman gave to those, or Scottish draftsman gave to those regulations would have to be considered as you put it in the abstract. You'd have the
so he may willy-nilly have failed to do what he probably intended to do, namely to reflect the precise meaning of the directive. He may actually have intended to go narrower without realising it, because he misread the directive. I mean,
no.
that again seems to me rather odd.
No, with respect, that's not what I'm saying. If the directive were not clear, say this court were to consider that the directive wasn't clear, then that would have been the same position for the draftsman, and the draftsman then would have had to decide what to do. In a situation where it wasn't clear what Article 4.2 of the directive meant, the draftsman would have to say, well, I have to implement them, I have a discretion, what set of regulations shall I make?
In what sense has the draftsman a discretion? These regulations were made under Section 2.2 of the European Communities Act 1972, yes, and not under any other legislation. And the power which is given in recital 24, I think recital 24 is really just stating the obvious. That in itself is not a provision of community law to which effect could be given by the 1972 Act.
The answer to that, my Lord, is this. Section 2.2, one would need to have Section 2.2 in front of one, but it gives broad powers to implement community obligations or to make regulations in connection with or related to. I'd have to go back to check the word. So there is a slightly broader domestic law interpretation to the scope of Section 2.2. Otherwise, one would have always the problems met with domestic law. If you didn't make it absolutely match with the directive, there would be an issue. But Section 2.2 does not provide for that. There is a provision to make subordinate legislation. I forget the precise words, I'd have to look at Section 2.2, but it's in connection with or related to. And there are a series of cases which I can certainly draw to the Court's attention, should they wish, dealing with the scope of that. There's a case called Oakley and a case called Ex parte Unison, which confirms that the regulation-making powers under Section 2.2 are not limited simply to implementing the community obligation, but are also broad enough to do ancillary or related matters.
Yes, but not to make substantive law.
It can do that, yes. There are cases that say they can do that, where it's connected with, where, for example, community law covers 90% of the territory, and you need 10% more, then you use Section 2.2. You don't have to find a different power to use for the other 10%. So it can make, as your Lordship puts it, substantive law, yes.
I think you may have misunderstood my early intervention. I was contemplating a situation where we found it evenly balanced looking at the regulation.
Ah, right.
I was taking the ground that you're taking, in effect, starting off with the regulation and finding myself in doubt as to what the draftsman was really getting at, particularly when we look at Regulation 12 and the way the balancing exercise is addressed there. And is it not right that one would then go back to the directive for some kind of guidance as to the context in which the regulation was being framed? And that leads one into the question as to what the directive means. So it's a process of moving backwards from the regulation.
Yes.
If we find it difficult to construe the regulation in the way you're arguing.
Yes, I certainly accept that. That is and must be correct in my submission. That must be correct. If you find that the regulations don't answer the position, you have no choice but to consider the directive, because as a minimum, the regulations are meant to satisfy the requirements of the directive. Certainly. So that is correct. The situation that I'm dealing with was a slightly different situation, where the directive was said to be uncertain one way or the other. And if the directive was said to be uncertain one way or the other, or not act clear one way or the other, then it may be that the regulations were capable of interpretation, even without the assistance of the directive.
But can you consider that without looking at the travaux behind the directive?
Yes.
That's a very bold answer.
Well, the question was, can I consider it? And the answer is yes, I can consider it. Indeed, we're about to. Should we is another question. Yes, you can.
What you mean is everybody up till now has, so why shouldn't we?
Everybody in this case and everybody in most cases, including the European courts. In a number of instances, when you look at the travaux préparatoire, even in Luxembourg, is very limited indeed. And the last time I sought to persuade the Luxembourg court in September to look at the travaux, they said it meant the exact opposite of what we'd said. Anyway, so the travaux préparatoire does not assist. But I think the starting point is to start with the regulations, see whether or not the regulations are clear. You cannot divorce these regulations from the directive in any event, because they are there to give effect to the directive, and the policy of the directive is to maximise access to environmental information.
Well, that was precisely my point, really. The idea that the parliamentary draftsman achieved clarity in a particular sense because he perceived that the directive left his options open, and he was uncertain as to what it meant, seems to me slightly remote. I rather suspect that the way this happened was that he just intended, as I said before, to give effect to whatever was the prima facie position under the directive.
Well, in that case, my lord, what I need to do is persuade you that I'm right on the domestic regulations first. If I'm wrong on that it's act clear that the directive means what I say it means. If I'm wrong and it's not act clear, and it's more evenly balanced, then your lordships will be under duty to make a reference under Article 234. You would have no option then. But that would be the third stage, when I've done my summary submission and looked at the regulations and the provisions of the directive.
So you want to start off with Regulation 12.1?
I want to start off with Regulation 5, if I may.
Regulation 5.
In summary, the wording of the regulations, the structure of the regulations, and the policy underlying the regulations, in my submission, does support our view that what you do is consider, in relation to each exception relied upon, where the public authority identifies an exception that it wishes to rely upon, is that exception applicable? And if so, does the public interest in maintaining the exception outweigh the public interest in disclosure? Where the authority wishes to rely on more than one exception, you have to go through each exception in turn and ask, is the exception applicable? And does it outweigh the interest in disclosure?
The interest in disclosure being the same in each case, I take it.
Beg your pardon, my lady?
The interest in disclosure being the same in each case.
The interest in disclosure being the same.
The exception's different, but you weigh the interest in disclosure against each exception.
Yes, exactly.
And are we here, has all this money been spent on this case because the respondents believe that they're less likely to have to cough up this information if their case is right?
That must logically follow. We say that can't actually follow in the facts of this case for this reason. The public authority relies on two separate exceptions: public safety and intellectual property rights. Each exception is applicable. Neither exception has been judged to justify non-disclosure. The Tribunal and the Information Commissioner looked at public safety. It said, yes, the Information Tribunal is engaged, but it's marginal. Doesn't justify non-disclosure. Did the same with intellectual property rights. It applies, but it doesn't justify non-disclosure. And in our submission, where you have two separate exceptions, each of which is applicable, but neither of which justifies non-disclosure, then you cannot reach a different result by aggregating the two interests, neither of which justifies disclosure, and then say the two interests together in some way justify disclosure. Nor are you assisted by referring to some overall public interest, as if that had a different content from the exceptions. It is the public interest in maintaining the exception that has to outweigh the public interest in disclosure.
What is the public interest in disclosure?
Well, the public interest in disclosure is a number of things. At its highest level, it is really what is set out in the recitals to the directive, which is transparency in environmental decision-making. The public has access.
I thought Article 1 told you what you needed to know. Didn't
Exactly,
it? I mean, it's
yes.
not well, it's paragraph 1 of the preamble.
Of the preamble, yes.
I mean, that as I read it, was setting out the public interest.
Exactly, yes. And the factors may differ. It may be very acute, for example, in one case, if you're dealing with an immediate planning application, as to whether something that's a bit more remote. But the public interest in disclosure, as my Lord Hope and as my Lady Hale says, is really the same, and it's in the first recital. It's increased public access to environmental information, and the dissemination of such information contribute to a greater awareness of environmental matters, a free exchange of views, more effective participation by the public in environmental decision-making, and eventually to a better environment. And I've summarised that in our printed case at paragraph 34.
Does that appear in these regulations anywhere?
No, the regulations reflect that.
I thought we were looking exclusively at the regulations at the moment.
I'm trying to look at the regulations,
Well,
but I've been sidetracked into the directive. I will shortly, at some stage this morning, look at the regulations, and then I will look at the directive. But for the moment, I've been sidetracked into
Well,
the
it's
first
not a sidetrack
recital.
at all. It's a very important thing to understand what the phrase means. And, the position is, I think, as Lord Savile's hinting, that there isn't anything in the regulations that actually identifies or defines public interest. One's got to take it from somewhere.
Yes, and that must be from the directive. That's why you can never look at the two entirely in separation or in isolation. I accept that.
Right.
And if you look at the regulations themselves, which are tab 1, all we know is that from the preambles there is that the regulations were made pursuant to section 2.2, and we know from regulation 2 that it means, as you see at the top of the next page, the directive, and is dealing with information.
Yes, I was really looking at this particular case, and if we look at paragraph 17 of your written case, the Stewart Report, that seems to identify what one might describe as two public interests: reliable and openly available information about the location and operating characteristics of base stations, which would help to reduce mistrust and might be of value in epidemiological, I find difficulty in pronouncing that word.
Yes.
So could it not be said that there are two public interests in this particular case?
What we would say, my Lord, is that there are two factors, or two facets to the public interest in disclosure.
Can you aggregate them? When you're asking yourself the question under Regulation 12, the public interest in disclosing the information, can you say, well, there are two aspects of public interest in this case. One is to allay the fears of the public, and two is to help medical research. And together, they amount to the public interest that is relevant to the present case. Could that not be said?
You can certainly, my Lord, as you will see from Regulation 14, and you're required to do this, identify the matters that are relevant to the balancing exercise under 12. And when you're dealing with the public interest in disclosure, you may well want to consider, and you would have to consider the individual matters relevant to the public interest in disclosure, because that may be relevant to the exercise. If you're dealing with an imminent planning application, you may need to have the particular information in order to deal with that. If you're dealing with an historic planning application, you may still be entitled to the information.
Yes, I'm not saying I disagree, but it just seems to me that when you're looking at one side of the scales, you're looking to see well, you have to start, do you not, by looking at the public interest in disclosing the information.
No.
And you have to start there, otherwise you can't do or you have to look at that, because otherwise you can't do the balancing
The
exercise.
starting point is that an individual is entitled under the regulations, without having to state any interest whatsoever, to have access to the environmental information. That is the starting point. If the authority wishes to refuse to comply with the duty, the second stage is that the authority must identify the exceptions that it seeks to rely upon. Then there is a need to identify, is the exception applicable? And then there is the need to balance the
you're
interest
quite right.
against
I was
the public.
starting at the Regulation 12 point, but the Regulation 12 point is the case where an exception has been relied upon, which falls within paragraphs 4 or 5.
Yes.
Then you've got to do a balancing exercise.
Yes.
You've got to look at the public interest in disclosing the information,
Yes.
and you've got to look at the public interest in maintaining the exception.
Yes.
Look, now, my question was concerned with the public interest in disclosing the information.
Yes.
If there is no public interest in disclosing the information, and there is public interest in maintaining the exception, obviously the exception applies. So at some stage, you've got to identify the public interest in disclosing the information.
With respect, my Lord, in our submission, that is not how the regulations or the directive operates. It is a given that there is a public interest in disclosing.
It's a given.
Yes.
Now, where do we find that?
Well,
Doesn't it come from the Aarhus Convention?
yeah, we have the Aarhus Convention, 15 copies with it, actually.
Yeah.
And you can start with the Aarhus Convention, then with the directive.
Well, again, forgive me for interrupting, but we're immediately moving off the regulations into the European context, are we not?
My Lord, I will make my position absolutely clear, if I may again. These regulations were intended to implement the directive, which is itself intended, as you see from Recital 5, to be consistent with Aarhus. You cannot, for example, have a situation where the regulations mean something that the directive does not permit. But, having said that, whilst reading these regulations against the background of the directive and indirectly the Aarhus Convention, and knowing under Regulation 5, for example, that a public authority has to make it available on request, knowing the background and knowing Recital 1 to the directive, there is a public interest which is a given in disclosure. That is the starting point. Under Regulation 14, you will have to set out the matters that you've taken into account, and the public interest in disclosure may have different facets or matters. You also have Regulation 12.2, my Lord. I don't know if your Lordship has looked at Regulation 12.2. A public authority shall apply a presumption in favour of disclosure. That's in the regulations itself.
Yes, I have looked at that. I'm not sure I entirely understand what it means.
It means at least two things, that the regulations do reflect the general presumption, as I said, the general fact that it is given that disclosure of information is seen as a public good, and therefore...
I hear you say it's given that there's a public interest.
Yes.
But I'm afraid I'm trying to confine myself to your narrow way of looking at the regulations exclusively.
Well, in answer to
I
that,
can't find anything in the regulations that says anything about public interest.
my Lord, I can only
I'm not
make
saying
a
there
submission.
isn't any, and in this case, there are two examples of what could be public interest in the Stewart Report. But a public authority will apply presumption in favour of disclosure. Speaking for myself, I don't quite see how that could have any meaning in view of Regulation 12B, save in the case that the balance is entirely equal between disclosure and non-disclosure, whereupon you apply the presumption and you solve that particular conundrum by saying, well, it's equally balanced, but the presumption is in favour of disclosure, so disclosure there shall be.
To respond to your Lordship's question, it's easiest to go back to first principles. There is no doubt that these regulations are intended to implement the directive. And there is no doubt the policy underlying the directive, and therefore the policy underlying the regulations, operates on the basis that an individual is entitled to access without having to state an interest. That's the first point, and to that extent, I accept that you cannot divorce the regulations from the directive. The second point is, do the regulations themselves contain within them the seeds of a policy that favours disclosure? And in my submission it does, because if you look at the entirety of the regulations, starting with Part 2, they are concerned with access to information, obligations to disseminate information and to make it more readily accessible, obligations in Regulation 5 to make it available on request. Regulation 5 does that because it is seen as a good that it is made available on request without having to state an interest. You then get to the exceptions. If I could finish this, my Lord.
Yes.
You then get to the exceptions, and there are limited exceptions restricting that. You start off with a regulation that says there shall be access. Then you get to a Part 2 that says that may be that duty may be disapplied in certain defined circumstances. You also have the presumption of disclosure, and you have Regulation 14, which says that you look at the matters, or you identify the matters referred to. In my submission, taken alone, but certainly in the context of the directive, the regulations favour environmental access on request. The question that I was dealing with is a separate question. On the question of interpretation of Regulation 12.1, is it possible to decide this case without a reference? And the answer is yes, if this court is satisfied the regulations mean what the appellant says it means. If, however, you are uncertain about whether or not the regulations, as a matter of pure domestic construction, may be a better way of phrasing it, if you are unsatisfied that you can reach that conclusion as a matter of pure domestic construction, and that you have to look at the directive, the second question for this court is the directive Act Clear one way or the other? If it is Act Clear in our direction, then that will supply the deficiency about the domestic regulations. If it is not Act Clear, then your Lordships have no choice but to refer.
Yeah. And what one's looking for in the regulations, am I right, is the process which the regulations identify that has to be gone through in reacting to the request.
Yes.
And I'm looking particularly at Regulation 14, 3B.
Well, 3A is helpful too, my Lord.
Indeed, of course,
Firstly,
3A...
you have to identify any exception. They're not talking about identifying the overall public interest. They're saying identifying any exception.
I understand that. You've certainly got to identify your exception. That's not a problem, I think, in this case, because they've been identified.
As
But
public safety or...
B is requiring the public authority to identify the matters that the authority considered in reaching its decision. So it may be, and I think you've accepted this, one gets a broad view of what the public interest considerations are in the preamble to the directive, for want of anything else. But when you come to the particular case, the authority is expected to identify what particular features it identified here, and maybe you go to the Stewart Report and find what are relevant in this particular instance. Would that be the line of thinking that we're invited to take?
You could do that, my Lord. In fact, in this case, as your Lordship will have seen from the judgments down below, the reason for the request, it was sent by Health Scotland, or whatever the title is for the National Health Service in Scotland. And he said, I want this information. He didn't actually state why he wanted it, because the whole point is that the request is, in the jargon, request blind or interest blind. You assume that the person is entitled to it. Yeah. You don't have a situation where he has to justify his or her access to it. And it was assumed that it was for epidemiological research from the nature of the information and the nature of who was requesting it. But if your Lordship wants to look at page 187, 89 and 90, you will see how the body concerned, Ofcom, actually dealt with it. 187 is the letter following the final review. This is in the core volume, 187. And you'll see at the bottom paragraph, following careful consideration, I regret to inform you that Ofcom will not disclose the national data set as you have requested. This information is being withheld as it falls under the exceptions in Regulation 12.5a and c of the Environmental Information Regulations 2004. In applying these exemptions, Ofcom has had to balance the public interest in withholding the information against the public interest in disclosure. That, of course, isn't the test, because it's maintaining the exception. But if your Lordships go to 189, you'll see the annex there, and it set out the first exemption that they were relying on, Regulation 12.5a, and it set out the factors for disclosure, which is the factors that my Lord Savile is referring to, and the factors for withholding, and then they gave the reason why the public interest favoured withholding the information under that exception. And then if your Lordships turn over the page, you'll see the Regulation 12.5c, public safety, again the factors for disclosure, which is effectively summarising the Stewart Report, versus the factors for withholding, and then they set out why they thought that intellectual property rights justified non-refusing. And what the Information Tribunal did was consider each exception. They accepted that 12.5a applied, but they said it doesn't outweigh the public interest in disclosure.
But are you saying that when one looks at the letter, the top of page 188 and the annex, what Ofcom has done is identify, in accordance with Regulation 14.3b, I think it is, the matters which they consider in the field of public interest are relevant to the particular exceptions.
Yes.
And they've set the area for debate at pages 189 and 190.
Yes, 189 appears to be the matters under B, the factors for and against. And if your Lordship looks at the opening words of 14.3, the refusal should specify the reasons, and that appears to be the bottom part of 189 and the bottom part of 190. And they've given the reasons for each exception.
Yes. So they're performing the task in the way that you suggest they should have done.
The annexes certainly perform the task in the way that we suggest they should. Ask whether the exception is applicable. If so, weigh the public interest in maintaining the exception against the public interest in disclosure, and they've done that, and then they've come to a decision on it. The Information Tribunal did the same, came to the opposite conclusion, and concluded that the public interest in maintaining the exception in 12.5a did not outweigh the exception. And then Ofcom, and indeed the Information Tribunal, did the same for 12.5c, and the Tribunal found that the exception applied because it might give some assistance to criminals, but it didn't have any strong adverse effect because the information was largely in the public domain in any event. And they decided that the public interest in maintaining the exception, that's safety, the public interest in intellectual property rights didn't outweigh the interest in disclosure of information. So you have a decision on each exception, they're applicable, but neither of them justifies non-disclosure. And we say the process of aggregation cannot lead to a different result. If neither exception justifies non-disclosure, putting them both in the same sentence or thinking about them both at the same time can't alter the fact that neither exception justifies non-disclosure.
So these proceedings are entirely academic?
They should be, but what the Court of Appeal said, if your Lordship go to paragraph 42, you can see the error in the Court of Appeal just by looking at paragraph 42 of the Court of Appeal's judgment. I think it's 42. Yes, 42 at page 18 of the core bundle. The Court said, I do not accept the Tribunal's concern that the aggregate approach makes the application of the exceptions unworkable or that it's capable of producing a nonsensical outcome. I see no greater difficulty in principle in looking at the aggregate public interest in maintaining the applicable exceptions than in looking at the public interest in maintaining a particular exception. In each case, a broad judgment is required. Just pausing there, that's not correct. When you go back to the directive, they talk about specific and defined circumstances. But moving on, it says, of course, it may be convenient in a particular case to proceed in the first place exception by exception. Well, you have to do that at the very least to see if the exception relied upon is applicable, considering whether each exception applies, and if it does, whether the public interest in maintaining it outweighs the public interest in disclosing the information. There is no objection to that course. Of course not, because that is what you do. Does the exception apply? If so, does it outweigh the public interest in disclosure? But then the Court says there is no objection to that course, provided that the matter is also looked at in the round, at the end of the process, by considering whether the aggregate public interest in maintaining the applicable exceptions outweighs the public interest in disclosure. There is no aggregate public interest that is different in content from the applicable exceptions. The two exceptions, looked at individually, do not, each of them, justify non-disclosure. Putting them in the same sentence, combining them, transferring them, aggregating them, cannot alter that simple fact. So where this Court has gone wrong, in my respectful submission, is having accepted that you consider each exception to see if it's applicable, and having considered whether or not the exception outweighs the public interest in disclosure. They then say, and then you stand back and you look at something called the aggregate public interest, or my friend calls it the overall public interest. But there is no such aggregate public interest or overall public interest. The interest is in maintaining the exceptions.
Well, is that approach not attaching too much importance to the grounds which are set out at pages 189 and 190? I mean, the argument can't be closed off about the public interest, by looking at the factors that Ofcom said they took into account. Is there not room for a broader view? I mean, going back to the preamble, the broad interest in disclosure and so on, which underlines the whole of the exercise. I mean, I'm not sure I follow the logic of your argument. I can quite see you can carry out the exercise that is invited by the presentation on these 2 pages, but there's a residue, surely, isn't there, of deciding whether, given the overall purpose of these regulations and the background, whether the result is the one that ought to be reached.
No, my lord, for this reason. The starting point is disclosure. Non-disclosure must be justified. It can only be justified in limited and specific circumstances. That is the exceptions in 12.4 and 5. That is the sum total of the material which would justify non-disclosure. If the factors relied upon do not justify disclosure when considered individually, there can be no separate interest which is different in form and content from those 2 exceptions. So there is no stepping back and looking at it in the round. There is only the consideration of the applicability of the exceptions and whether the substance of the exceptions applies.
In this case, it would be very odd if you could aggregate these 2 potential exceptions with their chalk and cheese or apples and pears. It might be possible to construct an example which would engage all of the exceptions, and then it would be rather odd to have to consider each of them one by one without looking at the thing in the round.
I make 2 responses to that, my lord. Firstly, there may be situations where the factors underlying one exception are also factors that would be relevant to another exception. If you're talking about, I want information about the location of the bases of our allies in the United Kingdom, the facts that you want to have information to that may affect defence because people know where they are and they can go and attack them. Those same facts may apply to international relations because the Americans, or whatever allies we've got at the moment, may say to us, don't you dare give our information about our bases. So it's the same facts, but they feed through to a different interest. But my second submission, my lord, is this, and I think your lordships do need to look at the structure of the regulations very carefully, because there is no way in my submission that the draftsman intended to aggregate the type of exceptions under Regulation 12.4 with the type of regulations exceptions under 12.5. They are very different regulations, and if I could just take your lordship to the structure of the regulations as well as the wording, that may be of assistance. If I could ask your lordship to go to Regulation 12. We say Regulation 12 is quite simple. It says there is a duty and you're relieved of it in certain circumstances. An exception applies, and if the interest in maintaining the exception outweighs, and you can have lots of exceptions and you might have 6 reasons, but all that does is define the circumstances in which the duty does not apply. But if your lordships look at 12.1a, an exception to disclosure applies under paragraphs 4 or 5. And then 12b, the public interest in maintaining the exception. And the suggestion of the respondent is that you have to aggregate all the exceptions. But that construction must apply to the exceptions in 4 and 5. You cannot say you must aggregate the ones under 5 or you must aggregate the ones under 4. It must be contemplating either what we say, you look at each individually, or what the respondent says, which is that you look at them in aggregate. But if your lordships turn the page and look at the kind of exceptions in 4 and 5, you will see that the nature of the exceptions and the tests that are applicable are very different. 12.4 is really dealing with some deficiency or flaw in the request or some matter relating to the nature of the information. 12.5 is dealing with the adverse effect or impact that disclosure would have on a specified external interest. If your lordship looks at 12.4, for example, you'll see that the test is the public authority may refuse to disclose information to the extent that, and 5 are set out. B, the request is manifestly unreasonable. C, the request for information is formulated in too general a manner, and the public authority has complied with Regulation 9. D is the material is in the course of completion. E is internal communications. So those are matters that are related in effect to the request or the nature of the material.
I don't find this a frighteningly powerful argument. I mean, I can see the force of what you're actually saying, but why are 4 and 5 necessarily to be accumulated if individual exceptions within 4 or 5 are to be accumulated?
It may not be a powerful argument, my lord, but could I please develop it?
Well, of course, but I mean, your case is basically that there is a fundamental difference, as there obviously is in the directive and the regulation, between what 4 is dealing with and what 5 is dealing with.
Yes.
But once you accept that, then you accept that there's a difference. You have to treat 4 and 5 separately, but it doesn't follow that you have to treat the individual components of 4 or 5 separately.
But if the exceptions are different in nature and type, the suggestion, and if it is difficult in practice, as I'll show you when I develop the submission, to aggregate the kinds of exceptions in 4 with the kind of exceptions in 5, that is a strong pointer that the draftsman did intend each to be considered individually rather than cumulatively. And you weren't meant to decide, was, for example, 12.4c applicable, was 12.5a applicable, and then to aggregate the public interest in maintaining the exceptions for general requests and public safety together. If I could just develop the submission a little, my lord, so you understand the way I
drafter
put
was
it.
just trying to do his or her best to track Article 4.1 and 4.2 of the directive.
Yes, I accept all of that, my lord. But that is not the point that I'm trying to make in the submission that I'm about to develop. The submission that I'm about to develop is this. We are looking at what the draftsman intended. Did the draftsman intend the following exercise? Consider each exception relied upon in turn and ask firstly, does it apply? Then you ask if that exception outweighs the public interest in disclosure. If more than one exception is relied upon, you do that sequentially. And if you look at 4 and 5, the submission that I'm trying desperately to make is that it is inherently unlikely, given the nature of the exceptions relied upon and the difference in test, that the draftsman did contemplate an aggregation of something in 4 and 5, and it is therefore inherently more likely that our submission is correct.
I don't think you're trying to make it. I think it's about the 3rd time you've made it, and it's in the case.
Could I just take you to 4C and 5A, just to explain how one sees it? If you look at 4C, the request for information is formulated in too general a manner, and the public authority complies with Regulation 9. Regulation 9 is the duty to give assistance if it's in too general a manner. So you decide whether, firstly, it applies, whether it's too general, and the authority is complying with Regulation 9. We say you then go on to weigh the exception against the interest in disclosure. If you look at 5A, the question would be, a public authority may refuse to disclose information to the extent that its disclosure would adversely affect, and here we're dealing with public safety, to take an example. Now, there are 2 ways in which it can realistically be done. Either you do what we say, that you consider the first exception, is it too general, have they complied with Regulation 9, yes, it's applicable, and then you go on and weigh that against the interest in disclosure. And you do the same with public authority. Is it applicable? Does it adversely affect? Does it outweigh? The alternative, if you're trying to work this through, is to say, well, C is applicable, it is too general, and they have complied with their duty. I won't yet deal with the balancing exercise. I'll consider the other exceptions relied upon, and in this case, it's 5A, public safety. Is that applicable? Yes, there would be an adverse effect. And then the question is, how do you then aggregate or balance 4C, which is looking at the generality of the request, and 5A, the adverse effect on public safety? We say you do each in turn and balance each exception against the interest in disclosure. And if that is done, then we say there's no way in which you can reach a different result by then going back and looking at it in the round. The alternative way of doing it is to say, well, I'll just decide applicability first, C applies, too general, comply to the request for assistance. Any other exceptions relied upon that are applicable? Yes, public safety. You would then have to give some kind of value to the interest in not complying with general requests, and some kind of value to the interest in maintaining public safety. And you then have to combine those in some aggregate fashion to weigh them against the public interest in disclosure. And it may be more complicated if the information is internal, if it's too general, if it affects public safety, and also deals with intellectual property. And the suggestion that you go through the applicability of the exceptions first, and then try and give them a value in some aggregating exercise to balance, is, in my submission and the submission of the tribunals who deal with this, unworkable. Or alternatively, you do what even the Court of Appeal said you do at the beginning, which is consider each exception in turn, see if it's applicable, and then weigh it.
Well, the tidy way, it strikes me, is what we see at pages 189 and 190. Bearing
Yes.
in mind we're dealing with examples here, as Lord Collins has said, that as often as apples and pears. You've got the line of thought is displayed quite fairly, I think, on these 2 pages as to what the public interest factors are in relation to each of these 2. You could do it this way. I think I've grasped you to saying if you did it the other way and simply identified the exceptions, you would have a 3rd page which would then set out the factors, and you'd actually find pretty well the same paragraphs put in seriatim, you say.
You'd have to do it in, the reasons why public interest favours withholding information, you wouldn't have that there for page 189 and 190. You'd have that really would be your 3rd page, taking the applicable exemptions that we've identified, which are 5A and 5C, and then you'd have to find some way of giving a value to those and aggregating both of those. And we say that situation is unreal, and I'll show you the tribunal decisions in a moment. It becomes more unreal when you're looking at the regulation, the exceptions in 4 and 5 together, because those are such inherently different, so qualitatively different in their nature.
But does it matter that they're qualitatively different? Because I think, among other things, the case put the other way is to say, well, you do look at each of these, and of course, if no public interest in withholding disclosure arises, well, you can cross it off your list. But you could end up with a list of 1, 2, or all or nearly all of 4 and 5. You then say, well, looking at all those, in all those, the public interest in withholding the information exists. On the other side, we think the following public interest arises in disclosure. In all the circumstances, we think the former outweighs the latter. Now, what is wrong with that approach?
What is wrong with that approach is, in our submission, it does not firstly reflect the wording of the regulations 12 and 14, which talks about identifying the exception. It's wrong as a matter of policy, because when we go back, and I know you'll say I'm now going back to the directive, but when you go back to the directive, what is clear is you're supposed to be having a policy in favour of disclosure. Disclosure is the general rule, and there has to be specific and defined circumstances in which you have disclosure. And you don't go into this kind of generalised aggregation of factors. And thirdly, in my submission, it is unrealistic and will lead to odd results. It leads to an odd result in this case, as the tribunal found, because neither exception individually justify non-disclosure. So how can they justify non-disclosure when you talk about it in the round? And generally, if you were to try and do it in a very complex way by dealing with application first for all the exceptions that are relied upon, and then trying to give values to each of those to weigh against the public interest in disclosure, we say that is not something that the directive or indeed the regulations contemplate. They contemplate that an exception would be relied upon. That's why Regulation 14 is in the terms that it says. You then decide whether the exception applies, and then you consider whether the exception outweighs the public interest in disclosure. And that's all you do.
Now, your basic point is that, leaving aside the obvious incongruity of trying to put 4 and 5 together, although some of the factors in 4 may come in under 5, for example, if you had a very broad defence and a very broad request you might say it's more likely to give rise, if honoured, to disclosure of matters relating to national security, for example. But your basic point is that these are not things which can be accumulated. To say there's a slight risk of a fair trial, of an unfair trial, and to try and accumulate that with intellectual property protection is, I think you're saying, bizarre.
I'm saying these are strange results and would be unworkable in practice. And I'm reminding the court that the purpose is to try and work out what the draftsman intended. It's not whether in an absolutely hypothetical world could we think up a situation in which it may be possible to perform this aggregation exercise on a set of hypotheses. The question is, what did the draftsman intend to be the process by which the policy of disclosure was maintained and exceptions were allowed only in specific and defined cases? And we say, when you look at the wording of 12, when you look at the structure of 12 and the different types of exemptions that would have to be complied with, and Regulation 14, which talks about specifying the exception relied upon, we say that all of those matters together indicate that what this draftsperson intended was the simple, straightforward exercise of saying the person is entitled to disclosure without specifying an interest. If a public authority wants to exempt themselves from that duty, they must say what exceptions they rely on. Then you consider each exception to see if it's applicable, and then you weigh that exception against the public interest in disclosure. That is all the draftsman intended to do. It leads to strange results, as here, because neither of the two applicable exceptions justifies disclosure, and there is no aggregate public interest which is greater than the content of the two exceptions. If you try to do it differently by dealing with application for all the potential exceptions first, and then trying to have an aggregation of values for each of those particular exemptions, it would be very, very difficult in practice to do that. And therefore we say, if one comes back to the question of what did this draftsman, in a context where he was trying to make it easy for individuals to get access to information, and trying to make it easy for public authorities to know when they could and could not comply with such a request, that is the interpretation that the draftsman adopted. We also say, and I'll show you the directive in just a moment, that that is consistent with, and we say, required by the directive.
Well, cases will differ, but what really is the objection to the example that Lord Nance was mentioning, where you get, for example, a 12.4c problem, that the information is the request too broadly formulated, coupled with a 5a problem, that if we
want all the base stations for the American Air Force.
Yeah. So, I mean, what's to prevent the Ofcom saying, well, these two taken together, we've weighed up against the public interest, and in responding to Regulation 14b, saying we've considered the matter in the round because they interlock with each other, this is the conclusion we've reached. Is there anything ruled out of order in doing that?
Yes, because it's quite clear from 14.3a that it is still focusing on the exception and weighing the exception against the interest in disclosure, because it talks about any exception. And the proper thinking is, why is this request for all the American telephone stations in Britain not acceptable? Answer, it's too general. And the factors about too general are, well, we don't know how many there are, we don't know which ones he wants, and so on. It's factors to do with, if you like, identifying what it is the person is after. And that's 4C. Then you get to defence. Well, hang on a moment. What does he want this for? It's not just we don't know how many Air Force stations there are. These are Air Force stations. This is a situation where there might be a real risk from some terrorist grouping and so on. So what you're looking at under 5A, defence, is going to be very different. So it may well be that a request will trigger off different chains of thought. But to say he's asked for far too many telephone stations, and they also belong to the American Army, and therefore we're going to give a value to how many stations, and we're going to give a value to the threat to defence and aggregate that, is, we say, not what was intended. It's the kind of, with the greatest respect, and focus thinking that the directive and the regulations eschew. And that's why you have a focus. What exception are you relying on? Is it applicable? Does it outweigh? So if it is general, why is it too general? Have you gone back and told them how to reformulate it? If it is too general, if it is a situation where you complied with your duty, and the individual just doesn't change the request, then you decide whether you should comply with it or not. The balancing exercise. If it's not only general, but a threat to defence, then you have to identify the threat to defence and weigh the threat to defence against the public interest in disclosure. It may well be that the very same telephone stations could be identified from the American equivalent of Yellow Pages. So it may be they'll say, well, it looks worse than it is, because in fact the information is readily available, and therefore the public interest in defence isn't actually here one that outweighs the public interest in disclosure. But the point is, the purpose of these regulations is to give you a right to the information and to force a proper, specific, defined justification for a refusal.
Is there anything more you want to say about paragraph 42 of the Court of Appeal's judgment which you were taking us through? I don't think you went the full way through the paragraph.
Just check, my lord. Well, it's the last part of it, my lord. Nor do I see anything nonsensical or unacceptable in the possibility of the aggregate approach resulting in non-disclosure in a case we're looking at each exception individually to result in disclosure. We've already had that discussion. Yes. It is nonsensical. Neither exception justifies it, but somehow putting them two in one sentence does. And I will shortly be taking your lordships at the end of my submissions to a case called Bovis, which is the new Information Tribunal decision that has come out. And when you see Bovis, you will see how the Information Tribunal, differently constituted, is having very real difficulty with the kind of approach that Lord Justice Richards is dealing with. In fact, it may be helpful to take you to Bovis now. It's at tab 18 of Bundle 2. And in a nutshell, my lord, Bovis built houses, and they were making a planning application in South Gloucestershire, and there was an issue about what's called a Section 106 planning agreement, and Bovis wanted to get the appraisals that the council had made about this particular project. That's paragraph 2 and 3, and you'll see at 3 that Bovis requested a copy of the appraisal. They started off under Freedom of Information Act, but in fact they all recognised it was environmental information. And there were two exceptions relied upon, as you will see from 15, paragraph 15. One, in fact, was a 12.4 exception. The request involved the disclosure of internal communications. And the second was the 12.5 exception. Disclosure would adversely affect the confidentiality of commercial information. The issue was set out at paragraph 19. And then at paragraph 33, you'll see they found that the first exception didn't apply. Last line of 33, the council is not satisfied.
I'm so sorry, which paragraph?
33, page 17, internal numbering. The last sentence on internal communications, the council has not satisfied us that the internal communications exception was engaged, so it decided that that one didn't apply. The next exception, the 12.5E1, commercial confidentiality, they concluded that did apply. And then at 43, they did the balancing exercise, and they came to the conclusion that, as you see at 47, the circumstances were such that the exception did outweigh disclosure. But it's really what they say at 48, and the difficulties...
Who's commercial, as a matter of interest, who's commercial confidentiality? The
It's the councils, because they would obviously extract a price for the planning agreement, and if they disclosed the appraisal they'd made, one of their negotiation tools would have gone. 48, as a result of our findings that only one exception applied, and that the public interest in maintaining that exception outweighed the public interest in disclosure, we are spared the necessity to consider aggregation of exceptions for the purposes of the public interest test. 49, we acknowledge that we are bound by decisions of the Court of Appeal and that it is our duty loyally to follow them unless overturned by a higher authority. We are aware that the decision of the United Court of Appeal is currently under appeal to the Supreme Court, and the following remarks are made by the Chairman and Dr. Fitzhugh only, and that's because the third one, Miss Tater, was actually a member of the Tribunal, as you see from the footnote, and she presumably felt it wasn't appropriate to make a comment on a decision that was the subject of appeal. We make no comment on the arguments of statutory construction with which the Supreme Court will be concerned, but we have to say that we have found ourselves unable to understand how in practice the Court of Appeal's concept of aggregating exceptions when applying the public interest test could produce different results from considering exceptions singly. Richards LJ dealt with the aggregation issue in theoretical terms without giving an example of how aggregation might make a difference in practice. We note first that some circumstances of a case may be of more relevance to one exception than to another, and it gives an example under FOIA. I'm 51, and I don't think this is in dispute. We do not understand the concept of aggregation as directing us to treat as relevant to a particular exception facts which are not in truth relevant to that exception. That must be right. If a fact is not relevant to an exception, that's the end of it as far as that exception is concerned. And then at 52, where in the circumstances of the case the public interest in maintaining a particular exception is outweighed by the strength of the public interest in disclosure, we are unable to appreciate how the balance can be reversed by highlighting the existence of other exceptions which are also outweighed by the strength of the public interest in disclosure. The statutory question whether the public interest in maintaining the exception outweighs the public interest in disclosing the information directs us, in figurative language, to make a judgment on relative importance. This is an intellectual, not a mechanical or mathematical exercise. Aggregation seems to mean thinking about the public interests in favour of all applicable exceptions at the same time. If, on considering all the circumstances, the tribunal judges that the public interest in maintaining exception A is less important than the public interest in disclosure, and that the public interest in maintaining exception B is also less important than the public interest in disclosure, we cannot see how thinking about both exceptions at the same time can somehow transform the public interests in maintaining them into something more important than the public interest in disclosure. We express the hope that the decision of the Supreme Court in the Ofcom appeal will provide the guidance which the tribunal needs in order to understand the balancing exercise which it is required to carry out. So there is an information tribunal saying, we are finding this, we're loyally going to try and follow it, but we are finding it very difficult to work it out in practice. We don't see how, just by referring to two separate exceptions which don't justify disclosure, you can then say there is somehow a different result by thinking about them in the round. Or, as the respondent says, talking about an overall public interest or an aggregate public interest.
With loyal friends like this, the Court of Appeal doesn't need any disloyal friends.
The impression I get is they are looking to the hills, my lord, from whence shall cometh their help. And they're raising their heights to the Supreme Court. The problems that they avert to will be solved, of course, if you do what we say you do, which is to look at each exception individually and then see if they apply and then see if they outweigh. And that is, we say, the practical and feasible way of dealing with matters. So if I may recap to where we have got to, my lord, I have dealt so far with my arguments on the regulation, and I don't need to repeat them. They are essentially the wording of 12.1, the structure of 12.4 and 5, the wording of Regulation 14, all of those, the wording and the structure and the policy underlying the domestic regulations, leads to the conclusion, particularly when backed by the considerations of feasibility highlighted by the tribunal, point to a situation where the draftsman intended each exception to be looked at individually. Does it apply? Does it outweigh the public interest in disclosure? May I then deal briefly with the directive? And that's in tab 1.
It's tab 5.
Tab 5, I beg your pardon. Bundle 1.
Yeah.
Just before you do, could you help me on Regulation 5?
Mm-hmm. Yes, my lord.
Does that duty only apply to environmental information which it is in the public interest to disclose?
No. It applies to environmental information which it holds, full stop.
So there doesn't have to be any element of public interest
No.
In the duty imposed by Article 5, by Regulation 5, beg your pardon.
Absolutely no. If you look at 3.1, these regulations apply to public authorities. 3.2, environmental information is held by a public authority if the information A is in the authority's possession, and has been produced or received by the authority, or B, is held by another person on behalf. And then 4 is the general duty to try and disseminate, and 5 is, subject to paragraphs 3 and part 3, a public authority that holds environmental information shall make it available on request. And when you go to the directive, you will see, my lord, that a key feature is you do not have to justify as an individual your request. That's why I say repeatedly it is a given that access to...
So the mere fact it's environmental information doesn't necessarily mean that it is in the public interest for it to be disclosed.
yes, it does.
This goes back to the Aarhus Convention.
It will do ultimately, yes, but it follows from Article 5, from Regulation 5. The mere fact that a public authority holds environmental information means that if it is requested, they must disclose. That is the cornerstone of the freedom of information.
Well, I'm sorry, I'm obviously misunderstanding, because I thought what I was asking you was, does the duty under Article 5 apply whether or not the environmental information, whether or not it is in the public interest for the environmental information to be disclosed?
It applies to environmental information which is held by a public authority.
Yeah, I follow that. So when you get to a particular case, you've got to, under Regulation 12, you can't just assume that it is in the public interest that it should be disclosed. Because it might be one of those cases where under Regulation 5 it has been disclosed because it's environmental interest, but where there is no public interest.
No, my lord, there is always a public interest. That public interest may be outweighed under Regulation 12.
Well, I'm sorry, I'm not following you, because if there's always a public interest, well then ex hypothesi, Regulation 5 is necessarily confined to environmental interest, environmental information, which it is in the public interest to disclose.
No, my lord. Regulation 5, I may be misunderstanding, and I apologise if I am. Regulation 5 is subject to Part 3 of this regulation, of these regulations. A public authority that holds environmental information shall make it available on request. Subject to Part 3, there is a duty to provide it on request. Full stop.
And then you've got 12.3, haven't you, which really, in effect, is making the same point in the presumption when you get to Regulation 12. Is that right?
It is 12.2, yes.
Sorry, 12.2.
Yes. But, and what happens under 12.1 is not that there is no public interest in disclosure, it is that the public interest is outweighed. That's the very reason for the choice of the language.
But the thing is assumed, isn't it? I mean, Europe wouldn't be legislating if it didn't regard that as being a general public interest in the disclosure of all environmental information.
It is a given.
It's one of Europe's preoccupations, A, the environment, B, disclosure.
One of the things that Parliament is concerned with, the freedom of information. Public information is public information. It's not secret. It doesn't belong to the public body. It is public information. In relation to the environment, for the reasons given in the preamble, there is an entitlement to have it. It will conduce as well to better environmental decision, but it is a given. And then there is a presumption in favour of disclosure, and only in narrow and specific and defined circumstances can a public body avoid complying with that duty. That is the structure. And
yeah, so to make sure I understand you, so when you get to 12, in effect, the public interest in disclosing the information is necessarily there.
yes, it is always there. It is a given.
And it's necessarily there because of the directive?
Because of the directive requires us to have it there, but because it's required to have it there, it is implicit in 5, that's what Regulation 5 presupposes. It makes it a duty.
But it isn't implicit in the regulations themselves, looked at in complete isolation, is it?
In my submission, it is in Regulation 5. You impose duties on people because to do a duty is a good thing. You impose a duty on an education authority to provide primary education for children because the provision of primary education is a good thing. You impose a duty on a public authority to disclose information that it holds because it is a good thing for it to do that.
Perhaps it's just worthwhile looking at the
definition of environmental information.
Yes, that's in 2.
That's in
It's the
regulation.
same as in the directives, it happens. And you, my lady is quite right, you will see the sorts of things there that are obviously public factor, what is the phrase I'm looking for?
Well, if
Public
you
interest
look at
matters.
A and B, the state
Yes.
of the elements
Yes.
of the environment, and the potential impact of emissions of all sorts upon that.
Yes, matters of great public concern.
We're talking about the air around us.
Yes, we're talking about,
What's being pumped into the air around
Yes.
us. Of course these are things we ought to know.
yes. And if the public authorities got it, they should give it to us. I'm not taking it from a private individual's secret safe in Hampstead Garden suburb. I'm looking at a public body and saying, you are a public body, you have produced or received that information. The obligation on you is to give us that information about the state of our environment. Or in C, to give us the information about the policies, the legislation and the plans. Or D, to report on the implementation of environmental legislation. We are talking about information, as my Lady Hale correctly says, that is information of public concern.
I mean, hearing you make these submissions makes me wonder, and it's not for you perhaps to answer, what Lord Justice Richards meant by the last sentence in paragraph 42, because he talks about the overall public interest. Now, if one's to detach oneself and look for something overarching over the particular factors mentioned in the letter, the overall public interest is page 18.
Yes, 18, yeah.
The overall interest would be simply what we've just been talking about, would it?
The overall interest is the
I
exception.
mean, just say, remind yourself that this is public information and there's a presumption in 12.2 and so on and so forth.
And there are limited exceptions, and they don't satisfy either exception because neither public safety nor intellectual property rights justify it. So to say, well, we've gone through all of that, we know it's public information, we know it's a public body, we know that neither exception justifies non-disclosure, but nonetheless, because of some overall, in italics, public interest, what is that and where does it come from? It does not come from the regulations or from the directive. And it does not come from the regulations or the directive, because the intention is, as I shall show you shortly, that the general rule is disclosure, and it has to be a specific and limited justification. And you do that by saying, is this exception applicable? Does it outweigh the interest in disclosure? Not by saying, well, they both don't justify it, but I'm going to look at them in the round, or I'm just going to look at applicability and try and give them a mathematical value and come to a kind of washing machine mix at the end.
Well, if all that's meant is you simply bear in mind as a sort of final check that there is the overall public interest. The overall,
There is no overall
well,
public
there
interest,
is.
my lord.
I mean, the overall situation is it's public information. I mean, if that's all he's meaning,
This is the overall public interest in non-disclosure,
Yes.
which he's referring to.
That's
And
the
that, it
problem.
seems to me, is the problem.
Yes.
That this business of stepping back and
Yes.
looking at the things in the round is a very frequent exercise when you're deciding some general question and a whole lot of particular factors, like, for example, fairness of admission of evidence in a criminal
Exactly,
trial.
yes.
You go through all the factors and you say it may create problems here. Now I must look at it cumulatively, step back, is it fair? But here there is no general conception to which to appeal.
Exactly, my lord. You have exactly the submission. You have a set of exceptions, and they either justify non-disclosure or they do not.
So if
and there
you
is no
put-
separate overall interest, which is different in content or form from the individual exceptions. My lord has it absolutely.
but if you put it the other way around, it wouldn't have been so objectionable. Just saying, bear in mind that, I mean, I know you don't like this,
Oh, you
public
mean Lord
interest.
Justice Richard rather than Lord Mans? Yes. Sorry. Yes. I see what you mean. Sorry, yes.
It's the non-disclosure word at the end, as if there
Well, the
was a
problem is
public
what
interest.
he considers, with respect, my lord, what he considers is not surprising is that even though two interests don't justify it,
Yes.
some overall undefined interest does.
Yes,
That's the problem.
It's the way round he puts it then.
Exactly, yes.
I follow what you're saying about public interest and disclosure, but when you get to 12.1b, the public interest in disclosing the information, you say is self-evident. You've only got to look at the
It is a
directive.
given, yes.
So, does that mean you're precluded from weighing any particular factors in favour of disclosure? For example, you could have a case where they're looking at the exceptions, and then they say, well, does it outweigh the public interest in disclosing the information? And could you then say, well, the public interest in this particular case is exceptionally strong, not just the general view that there should be transparency, but that this disclosure will have certain particular extreme beneficial effects. Are you precluded from doing that?
In my submission, you can do that. I'm trying to think of an example, and it's not a good example, but I'm thinking about swine flu. Say there was a suggestion that swine flu was something that resulted from a particular establishment emitting certain things into the environment, and that's where it began from. And there's an urgent and immediate need for Health Scotland or NHS Wales to try and find the source of the disease and so on. And somebody came along and says, well, this will affect my intellectual property rights. I can see a set of thinking which goes like this. Well, normally we accept that this would really adversely affect your property rights, and we'd have to weigh that against the general public interest, if you like, the given public interest in disclosure of information, and we think that on balance here the commercial interests prevail. I can see a situation where the public interest is so immediate and great in having the information that it might strengthen that side of the equation and diminish the other side of the equation. It's possible. And that would seem to be consistent with Regulation 14, which talks about the matters in the public interest balance, which must cover both sides of it.
Surely there are both general
Yeah.
features.
Yeah.
The general principles that are sitting there in the convention, in the directive, and in the ether, plus the particular factors that operate on the particular bit of information.
I'm content to accept that, my lady, and it fits with the reference to in all the circumstances and so on. Yes,
It's
I am
made absolutely clear by the directive as well.
Yes, and it fits with in all the circumstances and in all and Regulation 14. And I wasn't saying no; I was saying yes and giving an example
Yes.
with swine flu.
Or if you take nuclear emissions or something like that.
Yeah. Well, nuclear emissions would be, in many ways, a better example than swine flu, which is hypothetical, and I just thought of it.
Yes.
But nuclear emissions is better, yes. So you can take account of specific features of the general desirability of disclosure of public information, yes.
So public interest in disclosing the information is self-evident,
Yes.
but can be reinforced in the balancing exercise, looking at the words in all the circumstances of the case, with particular factors that make it even more important that it should be disclosed.
In that particular case,
Yes,
yes. And which makes the hurdle of justifying non-disclosure even harder, yes.
Yes.
I accept
Follow
that.
it.
Yes.
I accept that. I think, had I reached the directive, actually? Yes, I was about to start the directive at tab 5.
Before you get...
Yes, my lord?
Am I right in thinking the Aarhus Convention is that the relevant party is the EU rather than the member states?
Yes, you are correct, my lord. If you look at recital 5 of the directive, the
Right.
way it's taken your lordship through the directive, if your lordship looks at recital 5,
Yes.
is what your lordship said there.
Yes.
They've signed it, and
Yes.
they can be a party, and then they make a decision. And I'll be coming to the Aarhus Convention in just a moment. My lord, we've looked at the recital 1, which is the self-evident public interest in these information. Then, my lord, if you look at recital 8, it may answer my Lord Savile's point. It is necessary to ensure that any natural and legal person has a right of access to environmental information held by or for public authorities without it having to state an interest. So we've seen in 1 it's a self-evident good. We've seen in 8 it's necessary to have a right of access held by public authorities and that you don't have to state an interest. If your lordships would go to recital 16 on the next page, and this is a very important recital. The right to information means that the disclosure of information should be the general rule, and that public authorities should be permitted to refuse a request for environmental information in specific and clearly defined cases.
Yes.
That's the starting point. General rule, it's got to be specific and defined justification if they're going to get out of that. Grounds, plural, for refusal should be interpreted in a restrictive way, whereby the public interest served by disclosure should be weighed against the interest served by the refusal. And we say that read in context, this means not that you have a generalized aggregation of the grounds for refusal, but you have to have a specific and clearly defined ground, and the interest reflected in that ground has to be weighed against the public interest in disclosure. And we say there are really two reasons for reading the recital in that manner. Firstly, the general rule and the fact that the exception is focused on there being a specific and clearly defined case justifying non-disclosure. And secondly, you see the switch from grounds in the plural to interest served in the singular. And we say they're not saying look at all the grounds generally. What they're saying is what is the specific interest served by the particular ground and weigh that against the public interest in disclosure. As we say, is there a specific justification being advanced? Does that specific justification outweigh the public interest? And that is the two questions in 12.1. Is there an exception applicable?
It's not quite, actually. 12.1 is slightly more restrictive, isn't it? Because it talks about the public interest in applying the exception, whereas this only refers to the interest.
Yes, the absence of the word public is yes, that is correct. So that's recital 16, and that then feeds through into the directive. Your Lordships will have noted Article 1, objectives. Article 1, the objectives are to guarantee the right of access to environmental information held for public authorities, and to set out the basic terms and conditions of and practical arrangements for its exercise. That's what the directive wanted, and that's what we assume the draftsman wanted, not a mathematical exercise suitable for a tripos paper, but practical arrangements by which this right of access can be guaranteed, and whereby refusals have to be justified in specific and clearly defined cases, where that specific justification outweighs the public interest in disclosure. My Lord, Article 3 corresponds effectively to Regulation 5. Member States shall ensure that public authorities are required, in accordance with the provisions of this directive, to make available environmental information held by or for them to any applicant at his request and without his having to state an interest.
Sure.
He doesn't have to justify why he wants it.
So Regulation 5
Does
matches
the same.
that.
Because Regulation 5 has to implement Article 3, and it does do so.
Right.
And then, my Lord, you get to 4, which is headed exceptions. And Article 1 says Member States may provide for a request for environmental information to be refused if. And then there are 5 set out. And they correspond to 12.4 of the regulations. And again, they're ones to do with the request being flawed in some way, manifestly unreasonable in B, too general in C. And we say, of course, if you look at 4.1d, it concerns unfinished documents or material in the course of completion. We say the intention is consider if that's the case and then weigh it up and see if it justifies non-disclosure. And if you reach that conclusion, if you look at the end of Article 4.1, it says where a request is refused on the basis that it concerns material in the course of completion, then the authority's got to name the authority preparing the material and the estimated time. Again, an indication that it's looking at the exceptions individually. Does that apply? Does it, as we've seen, outweigh the public interest? If so, do what you can to help the individual to get it. So that's an indication. The very fact that they're in a separate article is an indication that they do be considered separately and not aggregated with 4.2, and we say separately within them. Then if you look at 4.2, Member States may provide for a request for environmental information to be refused if disclosure of the information would adversely affect. This is when it's looking outwards, an adverse impact or an adverse effect on specified interests, not some flaw in the request on material. And you see the various exceptions set out. And then you get to 4.2, after the list, it begins, and this is important, the grounds for refusal mentioned in 1 and 2 shall be interpreted in a restrictive way, taking into account for the particular case the public interest served by disclosure. In every particular case, the public interest served by disclosure shall be weighed against the interest served by the refusal. And this reflects the wording of the recital 16, and what they are clearly focusing on by the shift from grounds in the plural to interest in the particular, and bearing in mind recital 16, what they are talking about is the interest, the specific justification reflected in a particular ground of refusal. If that were not the case, then they would have said something very different. They would have said the interest served by the grounds of refusal, rather than the interest served.
Well, taking the third line of that little paragraph, it talks about the public interest served by disclosure, not the disclosure. So what is one to understand that phrase to mean?
The public interest served by disclosure?
Yes, I mean, is that a general proposition?
It's exactly what my Lady Hale said. It is both general and may have particular facets within it. There is always the general belief that public bodies must give access to publicly held information about the environment, but there may be particular facets about it as well. And that's why you've got the, taking into account of the particular case, you've got the general and the particular, which is also the point that my Lord Mance made. It's the same point.
So it's a given public interest served by disclosure without specification, but it may have particular aspects of it which may, as it were, strengthen or raise the hurdle, I think you said, yes, in the particular case. Yes. But you've got the general starting point, which applies in every case.
Correct. And then you've got to look at what the directive contemplated would be on the other side of the equation. And you bear in mind that 4 is the expression of the recital 16, that disclosure is the general rule, and that public authority should be permitted to refuse a request only in specific and clearly defined cases. And then you have the switch from the grounds to the interest served. And in our submission, what was intended is that the actual interest served by a refusal, what is the interest in the particular ground, has got to be weighed against the exception. And that fits with the general policy, the wording of the recital, and the emphasis that you're looking at a specific and defined case which outweighs the public interest in disclosure. You're not looking at a standing back and an aggrandizement of general factors or an aggregation of general factors. You're not doing that. The emphasis throughout is on focus. You should disclose. What's your specific reason for not disclosing? Does that reason outweigh the public interest?
I think there's pretty little doubt that the European Court would lay a lot of stress on the general importance of disclosure. It's in one of the Sweden cases, I think it's Sweden and Turco, on the directive, or is it a regulation? I think it must be a regulation, which deals with disclosure of community documents, and it's in the context of legal advice. There's an exception for legal advice, but the court said there is this is a regulation about disclosure. There is a fundamental public interest in disclosure, and that's the starting point. And that fundamental public interest in disclosure can override the confidentiality of the legal advice. And I think
that's consistent with
that's
what
the
you're
starting
submitting.
point. And the question then is, how do you measure the exceptions? And in our submission, it's not consistent with this starting point of disclosure and this emphasis there has to be a specific and defined, justified reason for non-disclosure, and to say you just stand back and you look at everything in Article 4.1 and Article 4.2 together and you get a kind of general feeling of where the overall public interest lies. That's not what the directive is talking about. And indeed it would be contrary to the directive if neither of the justifications in 4.2a and 4.2 the other one, E, intellectual property and public safety, if neither of those justify it, we say it's not possible and consistent with the directive to say, well, standing back from the fact that these two grounds don't justify it, and the interests served by each of those two grounds don't justify it, nonetheless, there is some kind of aggregation or some kind of overall public interest not referred to or hinted at in any of the articles that we've looked at so far, which nonetheless would justify it. But in my submission, the fundamental point is the whole structure of the directive and indeed of the regulations is to start with disclosure as the general rule, to provide that exceptions are specific and defined, and that, yes, there are grounds for refusal in 4.1, yes, there are grounds in 4.2, but you must look at the interest served by the refusal. What is the exception? What is the ground that you rely on? And you must weigh that against the public interest, including all the particular circumstances of the public interest in disclosure. That is what 4.2 says, that is the reflection of Recital 16 and the policy underlying the directive. And as my Lord says, it reflects, in fact, a general principle of community approach or even community law, that information, publicly held information, is something to which there should, in general, save for specific and defined circumstances, be access.
And do we go back to Recital 5 and Aarhus?
Yes,
in that context?
does your Lordship have Aarhus? Have your Lordship?
Yes, you do.
Right.
Yes, we've got it.
And you see Recital 5, which is the one that confirms that my Lord Collins said that it's been signed up to by the European Union, or it might be the European Community, but the relevant entity. And if your Lordships take Aarhus up, and you'll see from the recitals that, as my Lady Hale observed, this is all to do with things that individuals would be entitled to know about. The fifth recital, affirming the need to protect, preserve and improve the state of the environment. That's what you're talking about. Recognising that adequate protection of the environment is essential to human well-being and the enjoyment of basic human rights. Recognising that every person has the right to live in an environment adequate to his or her health and well-being. Considering that, to be able to assert this right and observe this duty, citizens must have access to information, be entitled to participate in decision-making, and have access to justice in environmental matters, and acknowledging in this regard that citizens may need assistance in order to exercise their rights. So that's the starting point. We're all entitled as individuals, as human beings, to certain basic things, including protection of the environment. And in order to be able to assert this right and to ensure the duties are observed, we must have access. That's the backcloth against which the Convention and then the regulations were adopted. And if your Lordships go through the treaty provisions, Article 1 is the same basic guarantee in order to contribute to the protection of the right of every person of present and future generations to live in an environment adequate to his or her health and well-being. Each party should guarantee the rights of access to information, public participation in decision-making, and access to justice in environmental matters in accordance with the provisions of this convention. That is the starting point. And then your Lordships have the definition at 2, and you have the definition of environmental information, which is broadly similar to the ones we've looked at. There are differences, but not material differences. And then 3, the obligation on the parties to take the necessary measures to implement the directive, and 3.5, states are entitled to provide for even broader access. And then 4 is access to environmental information specifically. And 4.1 is each party shall ensure that, subject to the following paragraphs of this article, public authorities, in response to a request for environmental information, make such information available to the public within the framework of national legislation, including, where requested and subject to subparagraph B below, copies, without an interest having to be stated, and in the form requested, unless there are certain exceptions. So that's the basic guarantee. 2 is it's got to be done quickly. 4.3 is circumstances for refusal. And it is, they don't hold the information, manifestly unreasonable or formulated in too general a manner, conserves material in the course of completion. So 4.3 is talking about those matters that are, if you like, procedural. They go to a flaw in the request, or something about the nature of the information concerned, and they're dealt with separately. Then you go to 4.4, and there's another set of exceptions in 4.4, and this is where disclosure would adversely affect certain specified, I call them external interests. Your Lordships know what I mean. And then again, you'll see at the end of 4.4, these grounds should be interpreted in a restrictive way. So, my Lord, that's where the general policy comes from. It's our human rights. Policy is disclosure. And again, the exceptions are specific. And in my submission, the very fact, because we're looking at what was likely to be the intention of the draftsman of Aarhus, of the directive, and then the regulations, the very fact that they divide these two types of exceptions into two sub-articles, Article 4.3 and Article 4.4, rather suggests that at least for those different type of exceptions, they did not contemplate that there would be some kind of aggregation. There's nothing to suggest you would take something in 4.3 and add it to 4.4. There's no reason to explain why 4.3 and 4.4 should be separate, unless it is to recognise that they are qualitatively different exceptions and a different test is applicable, and that you don't aggregate 4.3 and 4.4. 4.3 allows you not to disclose if there's something wrong with the request or the information. 4.4 will entitle you not to disclose if it would have an adverse effect on an external interest. When you get to the regulations, as I say, it treats 4 and 5 together, sub 4 and sub 5, and there's no possibility of saying you can aggregate 5 or you can aggregate 4, but you don't have to aggregate 4 and 5. It's all or nothing. It's quite clear that the draftsman of the regulations either applied the requirement that each be looked at individually, or they contemplated that all the exceptions in sub 4 and sub 5 could be aggregated. And as we say from Aarhus and from the directive, it is in our submission far more likely that when you're dealing with these different types of exceptions, there was no contemplation of aggregation by the draftsman of Aarhus, nothing to suggest 4.3 and 4.4 would be aggregated, and that follows through in the directive.
So the directive follows the overall scheme, or
Yes.
the Article 4 in each case are remarkably similar in their pattern.
Yes. And it has to do that because Recital 5 says that provisions of community law must be consistent with the Aarhus Convention. So just as our statute or regulations would have to be consistent with the directive, so the directive is supposed to be consistent with a higher norm of international law, which is the treaty to which the parties have signed up.
Well, why does Recital 5 say it must be consistent with that convention with a view to its conclusion by the European Community? Does that mean it hadn't come into force or something?
I don't know, my lord.
Because it recites they'd signed. May not matter.
We signed it on the European Union signed it on the 25th of Aarhus. I'm not sure when Aarhus. No, that was signed on the 25th of June 1998. I'm not sure whether there are... It sounds like what my lordship says, that there are ratification provisions and they hadn't been complied with. I don't think it makes any material difference to the case. Ah, yes, it's Article 19. Ah, yes, it is, yes.
Yes, I see.
Your lordship is right, it's Article 19.
But it hadn't come into effect by 2003 then?
It must have come into effect sometime since.
That seems, because Article 20 says it shall enter into force on the 90th day after the date of deposit of the 16th instrument of ratification. And I can't tell your lordship when that was.
In Article
It's
18...
in force. Miss Rose tells me it's in force now.
Yes.
So 16 states certainly have signed it. But I can't tell you what those words mean. I can tell you that it's my submission that make no difference in any event. But it looks as if my lord is right, and it's ratification and entry into force. But the clear structure is Aarhus first, directive, and then regulations. That's the way it cascades down from the sunlit uplands of international law.
Yes.
So, my lord, if we stand back from it, so far I have got the regulations alone. We say support the deal with each exception individually. Does it apply? Does the exception outweigh the exception? The public interest in disclosure. That's the wording and the structure. Then I've got my directive, which I say does the same, and then I've got the Aarhus Convention, which certainly appears to do the same as well. And it sets the framework in the sense we're talking about information that individuals are entitled to, and there has to be a specific justification, not a generalised, overall, aggregating public interest to refuse to disclose. The last topic I perhaps ought to deal with a little briefly is the Court of Appeal decision and why the Court of Appeal decision is wrong. But I've set that out very fully in my case, and your lordships may feel that it's all in the case. And when the regulations were clearly intended to comply with the directive and the Aarhus Convention ultimately, that references to the Interpretation Act don't apply. But there are other arguments that I've put forward in the case, and I'm quite happy to leave it on the basis of the information set out in the case, or to run through the various arguments briefly in relation to the Court of Appeal. I'm just conscious of time.
Yes, indeed. Well, the Lordships, of course, have read...
the case. Shall I do it very quickly, my Lord?
But pardon? I don't think you need to go through this. I mean, we've read the case, and you've gone through paragraph 42.
Yes.
So I don't...
The only other paragraph your Lordship needs really to look at is 37. 37 was the only real reason that the court gave.
Yes.
And 42, in my judgment, in my submission, explains the fallacy of the approaches that they've adopted, because they assumed you could have an aggregate interest that was different, and they're simply, in my submission, wrong.
Yes.
37 was, well, how did they get there? And they got there by applying the Interpretation Act,
Yeah.
and by saying the exception is in the plural. And there are four short answers, really. Firstly, Regulation 12 is simply setting out the circumstance in which the obligation does not apply. You don't have to comply if you can show an exception, and that exception outweighs. If you happen to have a number of exceptions that you can rely on, you will have 6 reasons for not complying. But that goes nothing to telling you about the balancing exercise, or that Regulation 12 tells you when you don't have to comply. And the 2 circumstances that have to be satisfied are 1, that there's an exception that's applicable, and 2, that it outweighs non-disclosure. And you don't need to get into singular and plural at all. That's not the purpose of Regulation 12. Secondly, if you look at Regulation 12 again, my Lords, which is in tab 1, and 12b, what the Court of Appeal did was to say, well, it must be the public interest, singular, in maintaining the exception or exceptions. But, my Lords, we say that the singular becomes the plural throughout, and it's the public interest or interests, plural, in maintaining the exception or exceptions. And once you have that formulation, it's entirely neutral as to whether or not the balancing test is done one way or another, so the Interpretation Act doesn't apply. My friend says in reply, but there is only one public interest. No. There are different public interests. There are all the different interests set out, for example, in sub 5. And we know that there are different interests, plural, because the regulations refer to them as interests, plural. If your Lordship looks at Regulation 12.6, for the purposes of paragraph 1, the public authority may respond to a request by neither confirming nor denying whether such information exists and is held by the public authority, whether or not it holds such information. If that confirmation or denial would involve the disclosure of information which would adversely affect any of the interests, plural, referred to in paragraph 5a. Now there they are talking, and would not be in the public interest under paragraph 1b. There they are talking about 5a, and they clearly see each of those exceptions, as is common ground, I understand below, as a separate exception or a separate interest. And that is why they refer to them in the plural. And it must be the case that if there are 4 separate interests in 5a, B is another interest, C is another interest, and so on. There is not one overall, global, monolithic public interest in this case. There are specific exceptions, defined and limited exceptions. And the question is whether those exceptions apply. So that's the second reason. Firstly, this case is not about the singular or the plural. Secondly, if you apply Section 6, it applies to all of it and it doesn't get you anywhere. Thirdly, the context in which this regulation is adopted is to give effect to the directive and Aarhus, and if we are right about the directive and Aarhus, then you would have to interpret the regulations in accordance with the directive, and the provision of Section 6 of the Interpretation Act 1978 would be irrelevant. And then fourthly, if you look at the internal indications in the regulation, it's clear that it's not meant to be plural or aggrandisement. If you look at the fact that there are 2 different exceptions, sets of exceptions in 12.4 and 5, if you look at the reference to any exception relied upon in Regulation 14, it's clear that the draftsman had throughout, in his or her mind, the fact that there would be specific exceptions relied upon by the public authority to avoid its duty, and the task for the tribunal would be to consider the exception. Is it applicable? If so, does the exception, that one relied upon, justify or outweigh the public interest in non-disclosure? So those are the four separate reasons why the Court of Appeal judgment is wrong in paragraph 37. Firstly, this is not a case about singular and plural. It's a provision that sets out the circumstance, the conditions that must be met for an exception. Secondly, it doesn't assist because Section 6 would have to apply to interest and interests as well as exception or exceptions. Thirdly, you would have to comply with the directive and that would displace the Interpretation Act. And fourthly, the internal indicia are that the draftsman was looking at the particular exception weighed against the public interest in disclosure. And you see that from 12.4 and 5 and from Regulation 14. My Lord, unless I could assist your Lordships further, those would be the submissions on behalf of the appellant. There is one other matter that I ought to deal with, which is the question of costs. I don't think it's dealt with in the case. As your Lordship knows, we are two very friendly regulators who've been litigating in a very friendly fashion. Throughout, each side, whoever has won, has borne its own cost. And we're not asking...
So we would make no order?
Exactly, because each side has borne its own costs throughout. We, for the fact that we won in the High Court, we still paid our own costs. Yeah. We lost in the Court of Appeal, but Miss Rose very kindly paid her own costs. And we invite this Court not to do the same, because this is really a question of interpreting the regulations for the future.
No one, just as a matter of interest, got a copy of the transposition note, which is referred to at the end of the explanatory notes in tab 1 under the regulations. It simply presumably indicates which regulation transposes which paragraph in the directive, but it may go a bit further.
I haven't looked at that, my Lord. I read the explanatory note, and that didn't seem to explain very much at all.
No.
So we didn't go on and look at the transition. Would your Lordship like us to look for it and send it to you?
Well, it might be interesting.
Right, can we make a note of that? Your Lordship, we will try and get that and send it to you as soon as possible, and obviously to Miss Rose as well.
Thank you very much. Mr. Chowdhury, do you wish to follow? No. Thank you very much. Miss Rose.
My lords, my lady, there's very little dispute, if any, between Mr. Lewis and myself on the overall policy and scheme of the legislation. We entirely accept that the Aarhus Convention and the directive and the regulations have the overall policy objective of guaranteeing and facilitating a right of access to environmental information. And we also accept that the basis of that is the policy considerations that Mr. Lewis has shown to the court concerning the general public interest in the making available of environmental information. But like so many fundamental rights, this is not an absolute right. It is a right which is exercisable subject to conditions. And the question before this court is how those conditions are to be applied in the particular circumstances in which a single request for information engages more than one of the exceptions which are listed in Regulation 12.5.
Can I put to you the point I put at the very beginning to
Yes.
Mr. Lewis, just so we know where we're standing, what your position is about a reference?
Yes, my Lord, our submission is that it is clear that there is no requirement in the Aarhus Convention or in the directive or in the regulations that each of the exceptions should be considered separately. On the contrary, in our submission, the natural meaning of all of those instruments and the underlying policy, and we submit the consequences that flow, the practical consequences that flow, powerfully indicate that, in fact, the correct approach, where more than one exception is concerned, is to look at the exceptions together and weigh them against the public interest in disclosure. And we submit that, that being clear, there is no reason for a reference. We don't seek to submit that there is any significant difference at all between the regulations and the directive. Of course, we accept that, as my Lord Mance put it, the draftsman here has been seeking to transpose into national law the principles that are contained in the directive. And it's very unlikely that in doing that he sought to draw any distinction between national law and the directive. Of course, if he had made national law less protective than the directive, he would be in breach of the directive and the Mar leasing principle would apply. But we submit it's equally unlikely that he sought to be more restrictive in permitting defences to public authorities, to gold plate the directive is equally unlikely. That the two should be construed together as a harmonious code in our submission.
Yeah.
And of course we accept that under the treaty this court has a duty to refer if this court concludes that the matter isn't that clear and that it would be determinative of the appeal. That must be right. But it is not our preferred course. I've made the submission that essentially what one has in this scheme is a right that is exercisable subject to conditions. And the question is how you apply the conditions. This is, of course, a concept very familiar to our courts in a whole range of different contexts. Just to give an example, the many qualified rights that apply under the European Convention, where typically what you have is a paragraph that sets out the right, such as the right to freedom of expression or the right to respect for private life, and then a paragraph which provides the exception, permitting the state, where it's necessary in a democratic society, to limit the right for a number of different interests, for example, protecting the rights of others or preventing crime and disorder. And we submit that what that structure reflects is a situation in which there has to be a balance in determining where the overall public interest lies. Does the public interest lie in the protection of the fundamental right, or is there some other specific public interest which the state is able to invoke which overrides the right? And in all such cases, you start from the presumption that the right must be enforceable unless there's an exception which overrides it. But it doesn't follow from that if the state, for example, were able to say, well, there are reasons to do with the protection of the rights of others and reasons to do with the prevention of disorder or crime, both of which justify a particular interference with a fundamental right, it doesn't follow that the right approach is to say, well, first of all, we're only going to look at the question of protecting the rights of others and weigh the strength of that against the right that's being infringed. And then we're going to do a separate balancing exercise. And this time we're going to take the prevention of disorder or crime and weigh that. In my submission, that is never the approach that's adopted, and it would be a most extraordinary way of proceeding.
Well, the draftsman of the regulations had quite a tidy mind, I think it's right to say. If you look at paragraph 14, which may be the way in which one begins the exercise, he's looking at the public authority, which is wanting to
refuse,
take itself out of the general rule.
Yes.
And obviously there's an exercise to be gone through, and we see how it's set out in Regulation 14, particularly 14.3.
Yes.
There's an obligation to specify things. So the mind has to be brought to bear. And, and it's an exercise which identifies, you've got to identify your exception, and then you've got to look particularly at B, to explain, if you are in this mind of refusal, what the matters are that you've taken into account.
Absolutely, my lord. And we submit that that entirely supports our position. Because, as my learned friend rightly says, what one has here is a strict scheme where there are a limited number of factors that may be relied upon as a reason for not disclosing information. They are exhaustively set out in Aarhus, in the directive and in the regulations. Absolutely correct that a public authority is not entitled to say, I think there's a public interest against disclosure which is not listed in Regulation 12.
So there's no overall public interest.
There's no residual public interest which is not specified. It is incumbent upon the state. This is why I drew the analogy with Article 8, because in Article 8 of the Convention you have a number of legitimate aims that are identified in 8.2, and the state's got to bring itself within the ambit of one of those. Similarly, here, we have a very detailed and specific list of public interest factors that the state is permitted to pray and aid if it wishes to decline to disclose information. And those must be specified. And if we look at
Sorry to
regulation
keep interrupting
14...
you. I beg your pardon for
Yes.
interrupting you, but just to get the terms
Yes.
absolutely right. There's a general rule, picking up, I think, the wording of the directive.
A general right. It's a general right.
It talks about a general rule, but it could be a general right as well.
There is a general right of access.
Which is it's on Regulation 5.
Yes.
Then we get to this chapter, which is dealing with the exceptions.
With exceptions, yes.
And you say these are very, very carefully defined, and it's as a list which can't be expanded because
Yes.
it's following Aarhus and so on and
Yes.
so forth.
Yes.
And therefore, it would be wrong to say, would it, that there's as it were, an overall public interest in non-disclosure.
My Lord, in my submission, no. Part of our case is that it is wrong to seek to divide up the public interest in that way and say, as my learned friend just did, there are lots of different public interests. There is only one public interest in any case. I'm going to show you, Lordships, a little later the case of Wiley, which is, of course, a public interest immunity case, where this point is dealt with by Lord Wolfe. There's only one public interest in any case. And what the public authority or the information tribunal or this court is seeking to do in every case is to identify where the public interest lies. And in every case, whether the public interest favours disclosure, which is the presumption, or favours non-disclosure. There are different aspects to the public interest on both sides of the equation. And this goes to a point that my Lord Savile made a little earlier, that in this case, there are particular aspects to the public interest in disclosure, epidemiological research, and people knowing about the location of mobile phone base stations, as well as the general public interest in disclosure that's described in the first paragraph of the recital to the directive. Now, in parenthesis, actually, the public interest in disclosure in this case was relatively low. And the reason it was relatively low is because most of the information that the public need about mobile phone base stations is already in the public domain
It's not
through the
very
website.
specific, is it? I mean, the point is made, you can't actually say precisely where it is within the given area. You don't know whether it's up a tower, on a church tower,
Yes,
or
that's
a pole,
right,
or
my Lord.
whatever else.
But for most people's purposes, the reason most people want to know where a mobile phone base station is they may be buying a house, they may be looking for a school for their children, and they're concerned about the effect of emissions on their children, and therefore they want to know what mobile phone base stations are in the area. They can go to the...
concerned about whether they'll get reception.
Well, they might, well, indeed, my lady.
I want to know.
Absolutely, my lady. And indeed, there was some fascinating evidence that showed, in fact, the more mobile phone base stations you have, the safer you are, because the lower the power of the emissions. It's when you don't have enough mobile phone base stations that you have higher emissions. But absolutely, my lady, that you may indeed want to know whether you've got coverage on your 3G network. So there are lots of reasons why the public may want to know, and they can access that information through the SiteFinder website, and it'll tell them where to a pretty good degree of accuracy, actually, where the mobile phone base stations are, who owns them, and lots of information about the actual characteristics of the station in question. But it won't give them the exact grid reference. No. And that was the real issue, the exactly pinpointing, and it won't give it to them on a national database. And the point was that this particular researcher wanted the whole of the national data set so as to do some statistical research. And your lordships and your ladyship will have seen that there was argument about that and the impact it had on intellectual property rights. But the submission I'm making is simply that the extent of the public interest on both sides of the equation has different aspects in every single case and may have different force. Now, my learned friend gave an example of a situation where the public interest in disclosure may be much greater, his swine flu example or the nuclear emissions example. But there are also cases, and we submit this is one of them, where the public interest in disclosure is relatively low because of the information that's already in the public domain. So this is not a swine flu case. No. But one has to look at the particular circumstances and assess the weight of the public interest in all of its aspects in favour of disclosure on one side of the equation.
But the equation looks different, doesn't it, if I've understood it correctly, that on one side you've got the duty or the general rule or whatever
yes,
it is, which
is presumption.
Is a presumption in favour yes. and so on and so forth,
yes.
which is perfectly general and can be made even more powerful by invoking particular aspects of it that apply to the particular case. But it's an irreducible element on that side, whereas on the other side, on the negative side, it's a very specific
yes,
list.
You have a specific list of
you've
factors.
got to bear in mind that the equation is unbalanced to that extent. That,
yes.
You've got this list which can't be expanded, which
yes.
is the interests against.
Yes, my Lord, I accept that. And of course, that's also the case when you're looking at a qualified human right, that you have an unbalanced equation. On one side of the equation, you have a fundamental right, and on the other, you have specific and limited interests of the state, which may override that right in the particular case. So yes, I accept that. But the question is then, how do you deal with the other side of the equation? And my submission is that it's wrong to say each of these exceptions constitutes a different public interest, and each is to be taken separately and weighed against the assessed public interest in disclosure. That's wrong in principle, because what you are seeking to do, whether you're the public authority or the court, is to assess the overall public interest in the terms that you are permitted to do it by the legislation. So you're not permitted to assess the public interest against disclosure by taking into account a factor that is by statute irrelevant. You're only allowed to take into account these factors, which are the only relevant factors. But in my submission, if you have two or more of them which apply, so you have two or more adverse effects on different aspects of the public interest, then in my submission, it is absolutely correct to take those together and weigh them together against all the aspects of the public interest in favour of disclosure.
Can you imagine an example?
Yes, my Lord.
Where it would make a difference?
Yes, my Lord. Let me give the court two examples. The first example, as the court knows, there is a presumption in favour of disclosure. So if the two rights, if the interest in favour of disclosure is equal to the public interest in maintaining the exception, the material must be disclosed. So let us say that you have a situation in which there are two exceptions engaged, and in which the tribunal looks first at one exception, weighs it against the public interest in favour of disclosure, and concludes that the two are equal. In that situation, in my submission, it is not only legitimate but necessary for the tribunal then to take into account that there is another adverse effect on the public interest arising from disclosure, and to say, well, that also has an impact, and those two taken together outweigh the public interest in disclosure.
But
and in my
what if
submission,
they're equal on the second one too?
well, my Lord, my Lady, in my submission, what you then have is a situation where there are adverse effects on two different aspects of the public interest. Each of those is equal to the public interest in disclosure. So taken together, they outweigh it.
But surely
Otherwise, you give no weight at all to one of those factors. It's the classic public law situation where you must take into account all relevant considerations.
Well, you say that several times
yes,
in your printed case. I'm just trying to work out. So you have factor one, the interests are equal.
yes,
Factor two, or
Yes.
exception two, the interests are equal.
yes. But
And
they're
you
different.
say-
They're different interests on the
They're all
negative
different.
side.
Well, then obviously the disclosure interests may be the same in each case,
They will be the
but
same.
the non-disclosure interests.
Yes.
Well, one could probably think of examples where they wouldn't be. The public interest answer on disclosure might be a different answer on some of the exceptions than to others. One could possibly imagine that. You've been thinking about this much longer than I have, and I haven't yet got one off the top of my head, but never mind. All I'm trying to say is I'm trying to understand your sums.
Yes.
Exception one, interests equal.
Yes.
So obviously you apply the presumption on whatever view of what the presumption
Yes.
is, you apply the presumption in favour of disclosure.
Yes.
Yeah.
Exception two, interests equal. So again, if one was treating them separately, one would apply the presumption in favour of disclosure. But
Yes.
you say the fact that you have two
You,
means somehow or other you tot up those two, but you don't give double weight to those two.
yes. And my lady, the reason is that what you're doing when you tot up is that you are identifying the fact that there are two adverse effects on the public interest that arise from the disclosure of this information. You're saying, what is the public interest in favour of the disclosure of this information? Well, it will improve debate on the environment and give people better access. So that's the public interest in favour of disclosure. Then you say, what is the public interest on the other side of the equation? And the answer is there are two adverse effects that disclosing this information will have. Firstly, it will have an adverse effect on, say, international relations or national security. Secondly, it will have an adverse effect on the course of justice. Those are separate interests. Both will be adversely affected. And we submit that if both of those aspects of the public interest are adversely affected, they must be considered together. Because
I'm still having trouble,
yes.
I've made my point, I'm
Yes.
still having trouble understanding how, if neither of those is individually
Taken alone,
sufficient
yes.
to outweigh the public interest in disclosure, putting them together makes any difference.
Well, because you are introducing into the equation a whole new set of adverse effects on the public interest. And indeed, one of the points that was made earlier
They
today...
don't accumulate, that's the problem.
Yeah,
They overlap, I think. I mean, your 50%, if I may say so, is
Yes.
a forensic point, but logically, if your point's good,
Yes.
it must be sufficient that there was quite a weak risk of unfair trial. I mean, 26% would be enough. If you had two 26% risks, you add them together, and then bingo, you've got 52%, and the public interest is and disclosure is outweighed. It seems to me that's the problem you've got to face.
Well, my Lord,
I think I see what you're saying, perhaps arithmetically. If you take the public interest in disclosure as being 100,
yes.
and then you take each of the exceptions, and you look at the first one, that is 100.
Yeah.
You then look at another one, which is also 100.
Yeah.
But what you don't then say is the public interest is another 100.
Yes.
So in other words, on my very simple example, 100 as against 200.
Yes. Now, can I just address with respect, yes, my Lord, but can I just address my Lord Mance's point? Because, of course, it's right to say that in practical terms, if both of the interests against disclosure are very weak, it is unlikely that considering them together is going to make much difference to your overall judgment. It's likely to be in the borderline case where this is going to make a difference.
Well, I'm not sure. I mean, you could have some extraordinary case which engaged A to down to G,
Every one in a rather weak way. On your case, they all accumulate, and that seems to me the problem that you face. Assuming it's an exercise required, it's an extraordinarily difficult one to know how a relatively weak or not conclusive factor under A accumulates with one under B or C or D or so on.
Yes, well, it may not always be an easy task, but in my submission, it makes more sense than the alternative, which is to ignore the fact that there are various adverse effects on the public interest arising out of disclosure when you do the comparison. And in my submission...
Well, I mean, the alternative
yes,
does make sense, doesn't it? I mean, if you look at it, I look at each of the hurdles which
yes.
has been put
yes.
up, and I conclude that they can all be overcome. And that's the end of the matter. Normally, in much reasoning, if you're faced with a problem, whether to build a house here, there, or whatever, you might well adopt a sequential approach. You don't say, well, there are an awful lot of difficulties. I can overcome each of them, but nonetheless, together, they are fatal. They mean this project's impossible.
Well, my Lord, with respect, you might well conclude that each of the obstacles to building your house taken alone might not make the house an impossible project, but the 5 taken together rendered it completely uneconomic. That may indeed be your process of reasoning. But can I just come back to a point that your Lordship made earlier this morning, making the point that the interests in Regulation 12.5 are quite different from each other. So, for example, in this case, we have an effect on public safety and crime, and we also have an adverse effect on intellectual property rights. Now, in my submission, if you start from the proposition that if the tribunal had found in this case that the adverse effect on crime and public safety of disclosing this information was equal to the public interest in disclosure. And then the tribunal says, well, actually, there is also another adverse effect that arises from disclosure in this case. It's a completely different type of adverse effect. It's the adverse effect on the intellectual property rights of the mobile operators. Now, in my submission, it is wrong to leave that out of account when you do the balancing exercise, because what you're seeking to do, in my submission, is not to look at each obstacle, but to assess whether the overall public interest does or does not favour disclosure. And what you've got is a situation where you have already determined that disclosure will have two different adverse effects on the public interest, and we submit both of those adverse effects must be taken into account when you seek to weigh them against the public interest in disclosure. Now, that can be graphically or numerically represented in my Lord Savile's equation, that you still have 100 on the side of disclosure and you have 100 for each of the adverse effects. But in my submission, one doesn't need to adopt an arithmetical or mathematical approach. It's the normal public law approach of assessing all the factors. And that, of course, is the approach that would be taken if we were looking at any other kind of qualified right.
We're constrained to some extent, surely, by the way the regulations are set out. I mean, if you look at Regulation 12.5, which we're talking about,
yes.
It talks about to the extent that,
yes.
And you've then got your list, and it ends up just before G with the word or.
Yes.
Now, in your example, where you're going to get either an even balance or less than an even balance of each of these, and applying the presumption none of them would win, how are you going to present your argument? How are you going to say, where is your justification? None of them will actually overcome the presumption. So to the extent that it would interfere with each of these, it doesn't succeed. How are you going to do it? I don't understand how it's going to be presented.
Well, let me give an example which directly addresses the structure of the regulations. One point which we have raised, which has not been addressed by the appellant, is what is their attitude to particular sub-paragraphs of Regulation 12.5, which themselves identify more than one interest.
Well, A is a good example. I thought
Lewis said that they regard those as separate exceptions.
Well, my lord, my lady, let's take it on that basis that he regards them as separate
I mean,
exceptions.
is that?
Yeah.
I think he said that in the context of interests in paragraph 6, but I mean, one questions whether that's right because they are grouped together for some purpose, presumably because they are closely connected.
Well, my lord, let's take it on the basis that he argues it first, and then take it on the alternative basis. So let us say that his approach is right, and each interest is to be separately weighed against the public interest in disclosure. So paragraph 1, we have international relations, defence, national security or public safety. Now, of course, I accept there's an overlap between these concepts, but there are differences, significant differences. Let us take national security and international relations. One only has to consider a case like the Corner House case, which some of this court will recall, or the Binyam Mohammed case, to understand that there is a very significant difference between an adverse effect on international relations and an adverse effect on national security. You may well have a situation, and indeed it's a situation which is shortly going to be occupying the Court of Appeal in the Binyam Mohammed case, where it is said disclosure of this information would cause great offence to our international partners and therefore have an adverse effect on international relations. That's one question. Another question is disclosure of this information would have an adverse effect on our national security because it would cause our international partners to take retaliatory action against us, perhaps with withholding intelligence cooperation. Those are different questions and different factors. And one can imagine easily, in fact, I've just given your lordships and your ladyship 2 real cases where those separate interests are both engaged, and in the Binyam Mohammed case, both engaged by a question involving the disclosure of information. And in my submission, can it realistically be said that when considering the question whether the maintenance of the exception, we would say maintenance of exception or exceptions, I'm going to come back to the actual drafting points later, outweighs the public interest in disclosure, that it is wrong for the national court or the public authority to consider both the effect on international relations and the effect on national security together. We submit that is plainly an impossible construction of this legislation, and if adopted, would be liable to lead to the forced disclosure of information in circumstances where it was plainly contrary to the public interest for that material to be disclosed. And I give that example because it's a very easy way in my submission to see that the argument, well, A doesn't outweigh B, C doesn't outweigh B, therefore A plus B cannot outweigh B, is, with respect, not correct. That when you consider A and C together as a whole, the overall effect on the public interest, the defined public interest, the permissible public interest, they may, taken together, outweigh the public interest in disclosure. And whether you call that an arithmetical approach or an overall approach, or simply, we would say, simply the weighing of both sides of the equation, the public interest.
Is that not right in thinking,
yes.
Sorry, to take you back to our Regulation 14,
yes.
3B,
yes.
am I not right in thinking that the starting point is for the authority to consider the particular exception?
Yes.
And set out the matters that it takes into account
yes.
in dealing with the particular exception?
Well, my Lord, in my
Is that
submission,
not right? I mean,
in my submission, Regulation 14 strongly supports our construction.
Yes.
Because if we look at 14.3,
yes.
which tells us what must be included in the refusal, first of all, the public authority must specify any exception relied on. Now, that obviously is envisaging that there may be more than one exception relied on, and indeed it's common ground that there will be many circumstances in which there's more than one exception relied on. So that's the first point. Then at 14.3b, the matters the public authority considered in reaching its decision with respect to the public interest under Regulation 12.1b. In other words, my Lords, having identified the exceptions that are engaged, the public authority must give its reasons for concluding that the public interest in maintaining those exceptions outweighs the public interest in disclosing the information.
Isn't that a misreading? I mean, 14.3b is
yes.
any exception, and then
yes.
the matters considered in reaching decision under Regulation 12.1b
yes.
means the public interest in maintaining the exception, or whether that public interest outweighs the public interest. So B has in it a specific, just as A.
Well, my Lord, that is, with respect, founded on the assumption that exception is to be read in the singular. If you read exception, there is exception or exceptions, that point evaporates. And that takes us back to the construction point, which I'm going to develop in a minute.
Even if you were wrong on the construction point,
yes.
do the words "in all the circumstances of the case" in 12.1b help you?
Yes, my Lord, they do. And they were, of course, also relied upon by the Court of Appeal. Can I perhaps take... Yes, sorry.
Just to make sure I understand your point under Regulation 14.
Yes.
You say 14.3a.
Yes.
Any exception
yes.
must refer to however many exceptions
yes.
have been relied upon.
Yes, any exception or exceptions, and that's the basic
Because otherwise
point.
you get the extraordinary case
yes.
Where a number of exceptions were relied upon.
Yes.
But only one can be mentioned.
Which is clearly not what these
which
regulations...
Which can't be the case,
no. And nobody suggests it is what it
and then you go on with B.
Yes. That is talking about an overall balancing exercise.
Reach this decision in respect to the public interest.
Yes, it's decision in respect to the public interest. And one sees throughout these regulations that the public interest is in the singular. And
public interest under Regulation 12.1b.
Yes.
Well, I
yes.
mean, that
now, can I perhaps develop the specific submissions that I make on the construction of these regulations before we break for lunch? Yes. Because we need to take them sequentially. If we start at Regulation 12.1, 12.1a. Subject to paragraphs 2, 3 and 9, a public authority may refuse to disclose environmental information requested if A, an exception to disclosure applies under paragraphs 4 or 5. Now, pausing there, picking up a point just made by my Lord Saville, the words an exception there must mean an exception or exceptions, because it cannot be the intention of the regulations, and it is not suggested by anybody that it is, that a public authority may only rely on one exception in a particular case when refusing to disclose environmental information. So that means exception or exceptions. And that, of course, is fortified by the Interpretation Act point, that it's a general rule that the singular includes the plural. And then at 12.1b...
Well, it couldn't, I mean, it could never be argued that that meant that if you have more than one exception, you couldn't refuse it. But I don't see that it follows that you need to read it as an exception or exceptions. It simply means that if it's an exception, if they listed 5, then there would be 5 an exceptions.
Your Lordship is more subtle than I am intellectually, because I cannot see the distinction between that and...
you don't have to read in the word or exceptions, I don't think.
Well, it's simply the point that the singular includes the plural. In terms of the obvious meaning of the regulations, and also in terms of Section 6 of the Interpretation Act. Then we come to 12.1b. In all the circumstances of the case, that's the starting point here, suggesting an evaluation in the round and by reference to the specific facts, the public interest in maintaining the exception outweighs the public interest in disclosing the information. And my learned friend has to submit that that must be read as the public interest in maintaining each exception considered separately outweighs the public interest in disclosing the information. And we submit that its natural meaning is the public interest in maintaining whatever exception is relied upon, whatever exception or exceptions are relied upon. Now, whether that means that the singular includes the plural, or if you've got a list of 5, you're relying on 5, and if there's a difference between those, the result is the same, that it's looking to an overall evaluation between two sides of an equation. One side, whatever factors the public authority is relying upon against disclosure, and on the other side, the factors relied upon in favour. So that's the starting point. We then have the presumption in favour of disclosure, which the court's already seen. We then have the specific exceptions at 4 and 5. We then have Regulation 12.6. Now, my learned friend sought to rely on this, but not to read out the last part of it. Public authority may respond to a request by neither confirming nor denying whether such information exists and is held by the public authority, whether or not it holds such information, if that confirmation or denial would involve the disclosure of information which would adversely affect any of the interests referred to in paragraph 5a and would not be in the public interest under paragraph 1b. And in my submission, the distinction there between the individual interests that are listed, the individual exceptions or interests that are listed under 12.5, and the public interest under paragraph 1b, which is of course the matter that we're concerned with, is significant, because that, in my submission, strongly supports my contention that what we're seeking to do here is to discern where the balance of the public interest as a whole lies, not to consider separate interests separately. We then have Regulation 14.
If you were wrong, how would that be worded?
Would involve the disclosure of information which would adversely affect any of the interests referred to in paragraph 5a, and in the case of each such interest, the adverse effect on that interest would outweigh the public interest in disclosure. We'd have to say something like that. Regulation 14, then, is to be read in the context of Regulation 12, which we have just looked at, and in my submission is entirely consistent with it, because what it is talking about is, first of all, the public authority must identify the exceptions that it says are engaged, and then 14.3b identify the matters that it's taken into account in reaching its conclusion overall. But then there are some further regulations here which the court hasn't yet looked at.
Can I just
Yes.
ask, I mean,
Yes.
could it be said against you on, say, take 5A,
Yes.
that the legislator here has decided what factors can be cumulated? There is an underlying common theme, similarly B, similarly perhaps D,
Yes.
and so on.
Yes.
And therefore, in a sense, the regulator has answered the point against you.
Yes. And I understand the point. That's the alternative to the first, to the way that my learned friend actually puts it. My learned friend actually puts it, as I understand it, that each of these interests is a separate exception, must be separately weighed. The alternative is the way that your lordship puts it to me, which is that each sub-paragraph is to be treated as a separate exception, and that interests within the sub-paragraph can be aggregated, but interests between the sub-paragraphs may not. In my submission, the first objection to that is why? It, with respect, is a wholly arbitrary way of approaching
No, I
the
mean,
scheme.
I think the point I was putting was that it's not arbitrary, that there is a common theme, and the problem that you face is that when you come to the aggregation of A, B, C, D, E, F, and G, there isn't any common underlying theme. They are disparate.
Well, my lord, the difficulty with respect with that argument is that there plainly are common themes between the other interests, and they are not disparate. For example, at C, we have intellectual property rights. At E, we have the confidentiality of commercial or industrial information, where it's provided by law to protect a legitimate economic interest, plainly closely related to C. And at F, we have the interests of the person who provided the information, where he wasn't under a legal obligation, didn't supply it in circumstances that he could be required to, and hasn't consented to its disclosure. Now, that's an example in my submission of 3 separate paragraphs where you have closely related and interlocking rights: commercial confidentiality, intellectual property, and voluntarily provided information. But there will also be many circumstances in which quite different rights will be engaged by the same request. Leaving aside this case for a moment and going back to Binyan Mohammed, there are in fact 3 rights that are potentially engaged by the disclosure of the information in the Binyan Mohammed case. One is international relations, one is national security, and the third is the ability of a person to receive a fair trial. Because it could be argued in the Binyan Mohammed case that the disclosure of the material, which tends to show the complicity of MI5 agents in torture in Pakistan, could adversely affect the ability of the MI5 agents to have a fair trial.
Well, that's
So
quite
that's-
a helpful example, but I mean,
Yes.
I quite see that there may be an overlap, but the exercise I would expect you to carry out is to look at A first and set out what you consider to be the interest grounds for withholding the information. And then you come to B and you do the same. And you may see immediately when you set them out that there is an overlap, and then you can weigh them up in that way. But
No, my lord, with respect, the overlap is not the point. The point is, we have to be very careful how we use the word overlap. The point is that it's the same information
yes,
which engages different aspects of the public interest. That's the overlap. I'm not making the point here that the same public interest could be characterised in different ways under different paragraphs. What I'm saying is that you may have the same request for information that may engage different aspects of the public interest.
Well,
Now, let me continue with the Binyan Mohammed example. Overwhelming public interest found by the court in that case, overwhelming public interest in favour of disclosure of the information, but very powerful national security reason for not disclosing the information. And suppose that the court concluded that the national security and international relations objections to disclosing that information exactly balanced the public interest in its disclosure. And then it was said, well, there is also a different adverse effect on the public interest, and that is the impact on the individuals getting a fair trial. Now, in my submission, it would not be necessary in that situation. Of course, this is assuming it's environmental information, which it isn't. But for the sake of argument,
You can have
but,
that
but
assumption.
that it would not be necessary in that situation for the public authority to demonstrate that the adverse effect on the fair trial rights of the individual taken alone outweighed the public interest in disclosure. It would be sufficient to say you must look at all of the different ways in which the public interest, the single public interest, is adversely affected by a requirement to disclose this material. And they include international relations, national security, and fair trial rights. And each of those must be weighed in the balance against the public interest in favour of disclosure. So in my submission, you simply cannot draw any sort of principled distinction between the interests that are contained within a single paragraph in Regulation 12.5 and the interests that are apportioned to separate paragraphs. It's a structure that has flowed through the international and European regulations, but never with any suggestion in any instrument that that structure has any impact on the way in which the relative public interest factors are to be balanced. But that's not suggested by any public instrument. My Lords, that may be a convenient moment.
Well, we look forward to continuing this discussion after lunch. 2 o'clock then.
That's not my problem.
No, it isn't your problem, because often if you're going to be kind to your advocate.